Today we're going to get through hopefully all of procedural fairness and that branch of review, and hopefully a couple scenarios as well, and more scenarios on Friday. But just to kind of do a recap using the checklist so that you can kind of get a feel for how you want to use the checklist, if at all. Let's kind of see where we've come based on yesterday. So that step one, before you approach any question, is does admin law even apply? And it's really not a lengthy discussion. In most cases it's going to, but just to flag that, is the decision you're looking at, is it even a decision of a public body? Just turn your mind, make sure it's not some kind of private type of contractual or private arrangement, and flag that. And then generally how you're going to dive into a question is to go through it and pick out, okay, which are the procedural types of problems and issues, and which ones are more substantive, which Deb will cover on Thursday. So substantive being problems with the actual decision itself. So today we're going to look at that first branch. And from yesterday, remember that step two, before you dive into, again, the analysis of either procedural or substantive, do a check to see, was there any right to appeal or reconsideration? Were there some kind of internal mechanisms in the statute? Maybe it's provided in the question, maybe it's not. But again, just to turn your mind to whether the person in the scenario has exhausted all of the internal types of review and appeal before proceeding on to JR. Some questions ask for your legal opinion, advise the client, write a legal memo. Again, that could maybe just be a one sentence. If you didn't have the information in the question, you may just say, you'd want to investigate whether the client has exhausted all internal rights of appeal and reconsideration before they would be able to proceed to JR. There you go, done. Okay. And your starting point, again, if provided, is always going to be the enabling statute. Okay. You could also refer to the fact you might have to look to a general procedural code. In Ontario, it's the SPPA, in case that may have some requirements that your statute does not. You'd go there before you'd consider the common law. And if there is some kind of internal appeal or reconsideration, then you'd want to look at, was that exhausted? What was the scope of the appeal? Were there any preconditions? What were the remedies? Just to, again, that might just only be a few sentences, but just to, cover that off before saying that the availability of a judicial review is possible. So step three in the checklist, if there is no statutory right of appeal, or let's say the right is limited, and you've exhausted all of those steps, then we can consider a JR. But remember, Deb talked about, there were those that JR is still a discretionary remedy, and there may be still times where the court, in looking at your judicial review application, may deny that application. Again, those are just factors to flag. So some of the factors before you're considering a judicial review, again, make sure that the decision maker in the tribunal is actually a public body. Does your client, let's say, or the person who wants to challenge the decision, is there any issue with standing? Do they have standing to actually make the challenge? If they don't, then you bring in that three-part test for getting standing. Do you have to consider which court you're applying to for judicial review? Is it a provincial or federal matter? Are there any time limits you have to consider? And again, these might only be, depending on how the question is worded, these might only be, these are the factors I'd want to pursue more, or these are some of the factors you'd want to consider, if you're not provided with all of this information. And you might not be. You're likely not given an entire statute that could answer all those questions, but in a one-sentence blurb, you could just turn your mind to, these are the things you would consider before proceeding. And again, we'll talk about this on the last day, or on Thursday, about remedies. Because it's also a practical consideration. Just because you could go to judicial review, is the remedy actually going to get you something that you want? Right? Is that going to be efficient, cost-effective, effective for your client by pursuing that, if it really in the end doesn't get you any different end result? So we're at this step 4. Well, we're a little past there, but we're kind of in the step 4 today, looking today at the procedural defects. And that step 5, the discretion piece, where the court could actually deny your application for judicial review. Those 5 core reasons, plus the 2 that Deb talked about, other remedies, prematurity, mootness, delay, misconduct, waiver. Okay? So consider all of those things that even if you've gone through all of the steps to get to a judicial review, is there any reason in your particular case where the application for judicial review might be denied? Okay. These are all the types of factors that are, again, if the question is provide legal advice to the client or write a legal memo, these can be nicely placed as, here are some of the other considerations, and then, put that in a kind of logical flow, I don't know, like a flow chart kind of way. Okay. Then in terms of scenarios, hopefully by the end of today, you'll have a sense of, after reading a question, what kinds of issues are procedural? What things are jumping out at you as possible procedural defects? And once you've gone through the scenario and found them, your first question is going to be, is a duty of fairness even owed? Because there may be some items in the scenario that are glaringly wrong, maybe no notice or no disclosure. However, you still want to go through it in a very systematic way to say the first step is there a duty owed? Because if there is no duty, it really doesn't matter what kind of procedural defects you find. And in order to answer that, is there a duty owed, you're going to look at those sources we talked about, right? The enabling statute, if it has some kind of gap, then maybe you can move to the common law. And in some cases, you may even need the charter to step in order to see what are the sources of where fairness is coming from and what are the triggers. And by trigger, I mean, at what point is fairness owed? And again, we talked yesterday, the threshold is quite low. So if you're already dealing with a decision by a public body about rights, privileges, you're going to have met that threshold. Okay? Some fairness is required. All right, so that's about as far as we got yesterday. We looked at the sources and the triggers. Today we're going to look at that second part. Once you've determined in your scenario, yes, fairness is required, the next, you can't stop there, then what does fairness look like? And so we're going to start today looking at, well, we'll finish up Singh, but for the most part, we're going to look at the Baker case. So there are 2 key cases in admin law, Dunsmuir for substantive and Baker for procedural. And Baker gives you a 5-step process or considerations, 5 factors, and they're not exhaustive factors, but 5 factors to consider when answering the question, what does fairness look like in each scenario? I'm just doing we're just at a review today. We haven't started yet. Okay. So any questions about the checklist or something yesterday before we move on today? All good? Crystal clear? No problem? You guys know this? Clear as mud? Yeah? Are you guys having fun yet? Okay, good question.
I don't know if it's good yet. In some cases, the court referred the matter back to the tribunal for in which kind of case the court substitutes its own decision.
Yeah.
De novo.
Really the only case where the court would substitute its decision would be an appeal de novo, meaning a certain kind of appeal where the court is not only hearing about particular defects in the lower case, but they're hearing the whole case again, bring the evidence back, bring the witnesses back. And an appeal de novo, your enabling statute will be very clear about what kind of appeal you're allowed. It's not that common. I can think of one scenario in the federal case around copyright, I think. The Federal Copyright Board, when you're applying for some kind of a copyright, you get a hearing. When you're not happy with that and you can appeal it, you can do the whole case again. Now, in the case of judicial review, because remember, appeal and judicial review are very different. In a judicial review, the court is never going to substitute its own decision. Never.
Right? Practically.
It may quash a decision. It may say this decision is not valid, so it's quashing it. So in effect, perhaps if the parties don't pursue another avenue or go back, perhaps that is in effect making a decision. But they're never in a judicial review hearing new evidence and coming to a new conclusion. It is really what it sounds like. It's a review. It's a review of what has taken place. For procedural, if the only problem was some procedural defect, then it will definitely say, yeah, you didn't get a fair process. Go back and try it again. And the process might be more fair, but your end result, whatever the decision is, might be exactly the same. Is that more clear? Yeah. Any other questions from yesterday? Okay, so we left off with the charter. Oh. Yeah. So we were just finishing off looking at that threshold question. When do you know that the charter can step in to enhance, I guess, and supplement procedural fairness? And there's a line in one of our slides we're about to get to, but I'm going to point it out now because it's an important piece. Just as a reminder, again, the enabling statute, if it's really clear in terms of procedures, then that is what you go by. And if it's clear and detailed, that doesn't leave any room for the common law to kind of jump in and either beef it up or supplement. Right? The common law can only step in if there is no statute, let's say, or there's a gaping hole or some type of, it's just not spoken to. The charter is a little bit different. The charter, even if a statute was very detailed about procedure, the charter, because it is a constitutional document, the charter could actually jump in to say, yes, immigration statute, you're saying that this is the procedure, but that is a violation of one of the tenets of the charter. So the charter could actually take that very clear statute and create a new procedure or require that a new procedure take place. Very different than the common law can only be used, you can only get into that analysis when the statute is not clear. So you could have a case where maybe a procedure doesn't look as fair as maybe you'd like it. But unless you get to the point of a charter threshold, and remember, the threshold is very high in order for the charter to be able to step in, right? We're talking terms like fundamental justice, life, liberty, security of the person. The charter is not going to apply in your most basic run-of-the-mill cases. There are cases, what we're talking about, someone's security, immigration, deportation cases, people detained.
Yeah, I think where it gets confusing and where it actually has come up in the NCA is where you have an economic sort of reason, where you have someone's livelihood being taken away, license to practice, or someone's license that has to do with their business. And then, that person is trying to claim, some sort of a level of procedural fairness is owed to them and is trying to use the Charter, Section 7, to say, this has pretty serious consequences for me and the Charter should be invoked.
Right. If I don't get this procedure, I can't get my license, I can't practice my whole livelihood. That is very serious, but so far the case law has said that doesn't meet the threshold. That
Pure-
economic security doesn't meet it, so far.
Yeah, but property is not, it's security, liberty of the person,
Yeah.
right?
What I'm saying, instead of invoking charter, the possibility of, in such scenario which you just mentioned,
The-
the business law, the possibility of invoking bill of rights.
Oh,
The
yes.
Bill of- if it's federal,
Yeah.
only if it's federal. If it's a provincial tribunal and a provincial decision, you cannot invoke the federal.
Yeah.
Right?
That's a good point. And
Yeah.
that is one of maybe the reasons why some people turn to the Bill of Rights. It has that very distinct language that could give you that opportunity for economic rights that the Charter clearly doesn't have, and the case law hasn't gone in that direction yet. So yeah, that would be good if you happen to have a federal scenario and it happened to be around economic rights, you could point that out. Yeah, yeah.
But there's a case in Montreal, Quebec, I don't remember the site. There's a restaurant, and the owner used to put up a bear for Jehovah's Witness. And they were supposed to get his liquor license renewed, but before it was renewed and he took it. I don't know if you claim it's Section 7 right, and because the premier back then intervened in the case.
And took the license away?
Yes.
Maybe he claimed Section 15, discrimination because of religious affiliation?
Probably mentioning a case that one of the that where he was helping particular sect, Jehovah's Witnesses and them with licenses.
That sounds like a Section 15, right? Discrimination on the basis of some sort of religious affiliation. Maybe it doesn't sound like the Section 7. Do you remember the name of the case?
I read it when I was doing constitution. I don't remember.
Okay.
Okay.
So constitutional, it's probably likely.
Yeah. We'll check it out. Yeah, it could have been on religious rights or, yeah.
He mentioned as a case one lady where he was the restaurant owner.
Yeah.
He was helping Jehovah's Witnesses
Mm-hmm.
and three were
Ron Corelli?
I think it's local. Yeah, that's the name of the one place.
Ron Corelli.
I didn't pronounce it wrong. But I couldn't
Yeah, yeah.
spell it out.
We know Ron Corelli. We know Ron Corelli.
I hope it's the same. Yes, it is the same.
Is that the same?
Yes.
Okay.
And probably he invoked his charge. Property is not right. It's affecting my life while I'm sustaining myself.
Yeah, and from a constitutional perspective, that would make sense. But this is admin, and I think that if you're faced with a charter-type situation, you may want to put a few sentences here that recognize that there may be an opportunity to raise, the basis of a Section 7 charter argument to trigger further procedural fairness requirements, but the case law as it stands views a pure economic circumstance or right or a pure economic violation as not sufficient enough to trigger the charter. And you're done. You got your points. You're
All of it by being economics is like, because without economics, survival,
But-
probably that's what he is attempting to do in this, that without my job, without my.
okay, and you can make that argument if you'd like
Make
to.
that argument that
But the case law is clear.
this license may lead to the driving, right to sustain.
Yeah,
the right.
but I don't disagree with you.
And
I
that's
don't-
what
we-
people have argued.
Yeah.
That is the, yeah.
I'm
That's the one argument which
Right.
court may or may not, it's unlikely to accept it.
right.
Because it's
As
sounding
as long as you recognize, if you want to go with that argument, that's great. But you don't want to lose those points by not recognizing that the court is really, not satisfied with pure economic rights.
Right. And again, let me just clarify, if you have a scenario where the statute doesn't speak to a certain procedure and you have that gap, you don't need to probably go to the charter. The common law will be enough. If you look at that three-pronged test in Knight that looks at the seriousness of the situation of the person, you can just say the common law itself is going to be, you're going to meet the threshold.
Yeah.
The only time you have a difficulty is when you have a statute that's very clear, so you can't use the common law, and then all of a sudden the only thing you have possibly is the charter. Yeah, yeah.
And that
Because if,
also
yeah,
only section 7.
and only, for our purposes, only section 7, yeah.
The old NCAs actually had 11D.
Yeah.
Remember? But yeah, you can focus on section 7. They've changed the syllabus.
Is it viable to invoke section 11?
They changed the syllabus, so
No, it's no longer,
you
No.
can check the syllabus. I don't think the current syllabus has 11D.
The past, a few years ago, actually last time it didn't have 11D either, right? A couple of years ago it did. Okay, so let's carry on with the slides today, and then we'll break around probably between 10:20, 10:30. So a little bit of a review. So we left off at section 7. So again, right to life, liberty, security of the
Sorry.
person. Yeah.
I'm sorry, do we have the tablet for any questions at
Oh,
home? It's here? No? Go ahead. Sorry about that.
I talked a little bit about that Section 7 has expanded into the possible right for representation guaranteed by common law procedural fairness. Remember I talked about the child protection case? And where we left off was just to note that what is unique about the Charter that the Bill of Rights does not have is that a couple sections actually that may make it okay at times to limit someone's rights. Now, you don't have to get, again, this is not constitutional, so you don't have to get too bogged down with it from a scenario perspective. You're not going to be doing a whole charter analysis on your exam. That's not what they're looking for. But just to note that it could be a limitation of the charter, that there are cases, Section 1 of the charter says, subject to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. So that's basically where there are times the government is usually the government making the argument, yes, this legislation may infringe some rights, but it's demonstrably justified. So Section 1 is this provision. It's unique to the Charter. It's not as relevant to Section 7, though, because Section 7 actually has its own kind of balancing feature in it when it refers to the principles of fundamental justice. However, state justifications such as the cost of changing procedures are often considered. So sometimes, again, this is the government coming up with certain justifications why perhaps the full gamut of procedural fairness or procedures isn't put into place. It's just a way that the government can justify that.
what's the acronym JED?
Pardon me?
This age, put in bracket JED.
That's the That's the family, that's the child, I think that's the child protection case, the JG case. I think that's the child protection case as well. Yeah.
I'll find it. You go on.
Okay.
Thank you.
Yeah, I might have just made it too much of a short form. Under Section 1 of the Charter, the court has held that infringement of Section 7 may be considered justified in extraordinary circumstances where concerns are grave and the challenges complex. So again, it's not a license to limit fundamental rights. A polarity exists between those who see liberty and security of the person as involving aspects of integrity, dignity, and autonomy, as well as physical and mental well-being, versus those who see it as protecting individuals from direct state interference with their physical liberty and security of the person. So in Singh, in the Singh case, an immigration case from 1995, the appellants were convention refugee claimants, making the claim that they had a well-founded fear of persecution. So that was the wording in terms of being able to meet the definition of refugee. Unable or unwilling to return to their country of nationality on the basis of fear. The scheme of the Refugee Act at the time was that a claim of refugee status involved an examination under oath by an immigration officer. A transcript of that examination was sent to the Refugee Status Advisory Committee. The committee advises the Minister of Immigration on whether a refugee claim should be accepted or not, and the minister decides. So that's the decision-making process. The minister, or probably a delegate of the minister. If the minister decides no, the appellant can apply for redetermination to the Immigration Appeal Board. The board will look at and asks, is there reasonable grounds to allow the claim? And if yes, they get a full hearing. If there are no reasonable grounds to allow the claim, no hearing, no refugee status granted, and reasons are given but only upon request. There is no provision for an oral hearing at any point unless the appeal board decides to give one. There is no opportunity for the claimant to see material that was relied upon for the refusals, either by the minister or the board decision. So this is your example of a statute, very clear policy here, right? Pretty crystal clear in terms of the procedures. The appellants claimed they didn't have a fair opportunity to present their claim, no oral hearing, and no fair opportunity to know the case that they had to meet. All they got was a no. There were no reasons until after the refusal. So the Supreme Court looked at, is this a case where you can use Section 1? Is this limit on someone's procedural rights, is it justified? And there are three questions that the court asked to determine whether limiting someone's rights are justified. Were the appellants entitled to protection for the charter? So first you have to make sure the charter actually applies. Was there a denial of procedural protection that should have been available under Section 7? And could the procedures be saved under Section 1? Was it demonstrably justified? So to that first question, are the appellants entitled to the protection of the charter? The answer is yes. You can apply Section 7 because there is a right to life, liberty, security of the person. Those rights are at stake when there is that fear of persecution and someone trying to escape it. So that's not so hard to see. The three distinct elements, the court must give meaning to each element. Okay? What does life, liberty, and security of the person mean? Security of the person, they found, encompasses freedom from punishment and threat thereof. In terms of that second question, was there a denial of procedural protection that should have been available under Section 7? And the test that was used was whether claimants had adequate opportunity to state their case and knew the case that they had to meet. The process they found, as it was set out in the Act, is insulated from the refugee, and the refugee is isolated from the process. The court also found that in situations where credibility isn't at issue, okay, that an oral hearing is essential. Okay? So this will be an important point. This could come up in a scenario. You don't always, fairness is not always going to mean you get an oral hearing. Very often you could use written submissions, but if the case succeeds or fails on the person's credibility and that person giving evidence, like it does in an immigration case, then you need an oral hearing. You can't assess credibility based on a paper review. You cannot establish on the balance of probabilities that the minister's decision was wrong because the claimant doesn't have access to the minister's basis for the decision. So that's a disclosure issue, and we're going to talk about that in a few minutes. Okay. No disclosure, no oral hearing. And third, the court looked at, can the procedures be saved under Section 7? So is it justified? The fact that time and money can be saved by not having full oral hearings, or the fact that it's administratively convenient to deny hearings, does not override the need to be consistent with the principles of fundamental justice. Okay? So you're going to hear that argument, and in some cases it is justified. Tribunals do have the ability to create their own procedures and rules, and it is a balance between efficiency and fairness. Because if you're too fair in a way, the system will grind to a halt. If you give everyone full hearings and let them take as much time as they want, you're going to have people waiting years and years and years and years for some level of justice. So there has to be that balance. In any case, the minister hasn't demonstrated, the court found, that the cost of running a hearing would be so prohibitive to fall within the meaning of Section 1. So that the government or the tribunal would have to show that the cost, the administration, was so excessive that it actually justified denying a certain level of fairness. So some of the commentary that came out of this case, before applying the charter, Wilson pointed out that express wording of the statute prohibited using common law. Okay, so here's that point I was making. In this case, you couldn't say, oh, common law can just come in and provide more rights. The statute was very, very clear, so that wasn't an option here. They found that the charter requires the court to override Parliament's decision about the kind of procedural fairness sought by the appellant. Okay? Again, keep in mind what you're doing here. Obviously, that was a conscious decision when that legislation was made. They weighed various factors, and in creating that piece of legislation, someone thought that that procedure was fair. So in order to invoke the charter, you're really overriding that legislative decision. The emphasis really in this case was on the dire consequences of the decision and the threat of harm that the refugees would potentially face. It raised the question that you must look at it case by case of what extent expense and administrative inconvenience would be a consideration. And administrative convenience is something that is considered in a Section 1 analysis. Okay, before we move on from the charter, the other kind of unique restrictive clause or limiting type of clause within the charter is called the notwithstanding clause. Parliament or provincial legislatures actually have the right to override fundamental freedoms using the notwithstanding clause. Okay? They can amend a statute to operate notwithstanding Section 2 or 7 or 15 of the charter. Okay? And in this case, no justification is required. So it's like the sledgehammer type of effect. But this notwithstanding, if a government is going to use this notwithstanding clause, it must be reviewed every 5 years. So an example, the Quebec language and sign laws, right, where everything is in French but not English. So you can see how on the face of it, there's an unfairness. There's a violation of some language rights there, but that law was put in place notwithstanding the fact it's a breach of Section 15. Saskatchewan had some back-to-work legislation that was also considered to be a breach of the charter, and Alberta at one point actually banned same-sex marriages. Probably a lot of provinces did at one point, but Alberta more recently had that ban. It's a clear violation of Section 15, but they were allowed to put that law in place, notwithstanding the charter. The government kind of used their, get out of charter free card in that case, but then once the 5 years expired, they didn't, because most provinces don't have that anymore, they didn't renew that legislation. They didn't ask for it to be renewed. Again, I would say this goes probably beyond what you need for admin law, but it's just another piece where the charter can be used, but you want to note that there are times where the charter can actually, the charter actually justifies a limit on rights. And then the last piece, I guess, on the charter that's important to think about is, well, what remedies do you get? What's available to you if you've been able to successfully use the charter to deal with procedural fairness? Section 24 is the right to challenge administrative actions that allegedly violate a charter. 24 says a court or tribunal can declare a law inapplicable in a particular situation. Only a court of competent jurisdiction may grant remedies under Section 24. Now, the Conway case that we looked at yesterday basically confirms that tribunals can deal with charter issues. Court of competent jurisdiction, as long as the tribunal, I think the test is, as long as the tribunal can deal with questions of law, then they can deal with charter arguments. And it'd be hard to think of too many tribunals that don't have the ability to deal with questions of law. Right? That's what they're doing. They're interpreting statutes. They're applying the law. Does it apply to the tribunals? Check the enabling statute. Some statutes will actually say that the tribunal has the ability to interpret the charter. Some may actually say they do not. So that's probably what you want to look for more than those that say they can interpret the charter. The tribunal must possess jurisdiction over the parties. Okay, well, if the parties are appearing there, they're going to probably have jurisdiction. They have to possess jurisdiction over the subject matter. And then jurisdiction to grant the remedy requested. Now, this is where in Conway some tribunals are going to maybe have some difficulty, that tribunals are going to be limited in the kind of remedy they can grant. So they can only award remedies that are actually available under their enabling statute. So overruling maybe the decision maker, refusing a procedure, granting a stay on adjournment, refusing to apply a law perhaps that breaches the charter. I think in the Conway case, what the applicant was what Mr. Conway was looking for was actually not a remedy available under that particular statute. So he was able to use the charter, but the remedy he wanted wasn't available. Section 52.1 is the other remedy section in terms of the charter, and it says to declare unconstitutional a law or to be void. Can a tribunal strike down a law? Well, this will depend on whether the legislature intended the tribunal to have that power to interpret the charter. Again, where do you go to find that? You go to the enabling statute. Does the enabling statute give the tribunal the power to interpret the law, or is it implied? It's going to be implied in a lot of cases. And if so, is there a presumption that this power will include being able to consider charter questions? If the tribunal can't for some reason, or if the parties opted not to, then they would take that constitutional issue. If they're looking to strike down a statute, they might take it to divisional court or superior court to have that looked at separately from the actual whatever's going on at the tribunal. That would be another option. In that case, if that happened, then you would likely stay the, whatever's happening at the tribunal. Let's say it is a human rights case. They would stay that, deal with the charter challenge, deal with the constitutional issue, and then come back with that decision and deal with whatever's happening at the tribunal.
Is there any statute with such powers? It's unbelievable that Parliament make it statutory body and law it to scrap that law under which it is supposed to come. It seems to be very unlikely that on ground we have such a statute.
Yeah. I think it's very unlikely. I can't think of an example off the top of my head where a tribunal member would deal with that and have the power to strike down a law.
The same law under which they are functioning.
Right,
It's something very
right.
unlikely.
More likely is the case where they might find a section to be a violation, so they might not apply a section to strike down. I can't think of an example. That's going to take place in a superior court.
These are
Yeah,
an odd section,
yeah,
they may give, which is again applicable to any.
yeah.
This, not from their point of view, otherwise it needs a discussion.
Yeah. And so, again, you're not going to have to get into high level of detail from an admin perspective, but what you really want to take from it is again, maybe it's only a one sentence, that if you are going to invoke the charter, that consider whether the enabling statute allows you to get the remedy you're looking for. And the Conway case, though, clearly stands for, yes, a tribunal can deal with charter issues as long as they can, they have the jurisdiction.
Which is the case in which any court has given this judgment that
That's the Conway case. The Conway case that we looked at yesterday. Yeah. Yeah.
We're going to talk about that in
Again?
substantive as
Okay.
well. When we do the overlap of charter issues in substantive review, we'll talk in detail about Conway. Just to mention the JG, do you want the full case? It's New Brunswick Minister of Health and Community Service versus GJ. New Brunswick versus GJ, but they call it JG. The full site. Do you have that green, do you have the books? Do you have the red book and the green book? So it's New Brunswick Minister of Health and Community Service versus GJ. Sorry?
Can you come again slightly slowly?
Say it more slowly.
Oh, New Brunswick, and then in brackets, Minister of Health and Community Services. It's a constitutional case from 1999, and it's one of those cases where the minister is applying to have control over 3 kids to extend the guardianship.
Okay. Is the CAS case, is that one, with the representation?
Yes, that's the one with the representation. And then the mother says that, part of my fundamental sort of procedural justice is to have a representative, a lawyer. Because without one, it's a violation of Section 7 of the Charter, security of the person, because it's a custody issue of losing the kids. So then the Supreme Court, so it's a constitutional case that has impact on procedural fairness in admin law. And we've talked about it when Liz, reviewed charter issues, and we also talked about it yesterday when you talked about access to justice, right? So if you're faced with serious consequences, again, invoke Section 7 and see if you can make that argument, connect the security of the person to a procedural fairness trigger, like the right to be heard, the right to participate in a hearing, and you'll have to argue that without adequate representation, you can't really present or defend your case, right? And the way this came about, obviously, because she didn't qualify for legal aid. Again, back to the access of justice.
It is versus JG or GJ?
It's versus GJ, but in all the books, it's also mentioned the JG. Because the way you cite it is different from the actual, you'll see. Because don't forget, it's an appeal. it's a decision with an appeal with a Supreme Court, so it goes back and forth. But JG or GJ, it's your choice. New Brunswick versus GJ is the last citation.
Thank you.
No problem.
Okay. So we're back to our checklist here. We've now got through that if a court determines that the threshold for procedural fairness has been met and the duty of fairness applies, consider the limitations. We talked about those yesterday. So do any of the limits apply in terms of, is this making legislation? Is this an emergency? If there are no limits on why the duty of fairness should apply, then you can move on to step 2, which is the content of the duty. So what does fairness look like? In each particular case, what kind of procedure does the decision maker have to follow? Very context specific. And again, you really do need to go always back to your sources as guidance of what fairness is going to look at. And those sources, again, if you have a clear statute, that's what fairness is going to look at, whatever the statute says. So if you don't have that clear guidance, then you can move into the common law. Okay? And there's a lot of flexibility here, as you'll see. That's where you can say, well, now we have to look to the Baker questions, the Baker case, to figure out what does fairness look like. So Baker is the leading case, and what comes out of it are the 5 criteria that are relevant to determining the content of the duty. And the court is clear, it's not an exhaustive list. There's not one that's more important than the other. And in some cases, some of them won't really apply. But you'll want to turn your mind to each of them. And when you're using these in an exam situation, I think the caution has been in the past, always be careful. We're giving you like this list and this checklist, lots of lists and limits. Be cautious that you're not just throwing in the list, but not applying that list to the actual fact scenario. So there may be some of these items that aren't relevant to the scenario they give you, and they're not looking for a complete regurgitation of lists, of just a list without the application of the actual facts. So the 5 that we'll look at in some detail now are the nature of the decision being made and the process followed in making it, the nature of the statutory scheme in terms of how that body operates, the importance of the decision to the individual or individuals affected, the legitimate expectation of the person challenging the decision. So you see where that's now, we talked about this yesterday, it's now coming into the content as well of fairness as well. Yesterday we talked about legitimate expectation in terms of more of a threshold. And then number 5, the choice of procedure made by the agency itself. Okay, so first let's look at, in a minute we'll look at, I guess, what the Baker case was about. After we go through that, we'll look at some of the specific elements of fairness, or some of the specific procedures, like notice, disclosure, oral hearings, the right to counsel, the right to call evidence, timeliness, and delay in the duty to give reasons. But first, a little bit of background on the Baker case. So regulations under the Federal Immigration Act permitted the Minister of Immigration to exercise discretion and allow a person to be admitted to Canada or to remain in Canada on humanitarian and compassionate grounds. Ms. Baker came to Canada as a visitor in 1981, but she remained here illegally 11 years, during which time she had 4 children. She became too ill to take care of her children, and it came to the attention of an immigration official that she had been in Canada illegally, and she was ordered to be deported. She requested that she be allowed to remain in Canada on humanitarian and compassionate grounds and supplied medical and other documentation, but her application was denied. An immigration officer wrote a letter rejecting her request, stating that there were insufficient grounds, but provided no reasons for this conclusion. So So immediately in a scenario, if you see something like decision but no reasons, that should send some warning bells to you right away. Through her counsel, Ms. Baker obtained notes prepared by the immigration official from the immigration officials set out in detail why he considered the application should be refused. Ms. Baker challenged this decision, and keep in mind in this case that what they're calling the decision really are just the immigration officer's notes. She challenged on two bases. First, she said that she was denied procedural fairness. She claimed that the duty required an oral interview before the decision maker. She said that they required notice to her children and the other parent, a right to the children and other parent to make submissions at the interview. Fairness required notice to the other parent of the interview and them to have counsel present, and that fairness also required reasons for the decision. The second ground, she also claimed that there was a breach of procedural fairness on the basis of a reasonable apprehension of bias. And now we'll get into that in a little bit, but in regards to the officer's notes, because in this case, the comments that the officer made in the notes were showed quite a prejudice and quite a bias towards Ms. Baker. Right? There was a real tone about her, and that she had all these children and she had been here illegally. There was a real kind of negative tone and flavor to those notes. The Supreme Court accepted that in these circumstances, she was entitled to procedural fairness. The main task for the court then was to determine what was the content. Okay? What should fairness look like? As a starting point, the court stated that the existence of a duty of fairness does not determine what requirements will be applicable in any given set of circumstances. Okay? So you definitely want to note that it's a context specific, right? The content of fairness or procedural fairness is very context specific when you're using the common law. The duty is flexible and variable and depends on an appreciation of the context of a particular statute and the rights affected. The court concluded that there was a violation of the principles of procedural fairness because of reasonable apprehension of bias on the part of the immigration officer, which came from his notes, and because the exercise of discretion was unreasonable in that the decision maker failed to give substantial weight to the interests of the children. Where the interests of the children are minimized in a manner inconsistent with Canada's humanitarian and compassionate tradition and the minister's guideline, the decision will be unreasonable. The matter was returned to the minister for a redetermination by a different immigration officer. So here you have a good example of what happens. Yep, she didn't get proper fairness. It goes back for another decision. Now, obviously to another officer, but you can see there is a chance she could still be deported. And they could still come to that same decision. Maybe unlikely after the Supreme Court has put the microscope on your agency and said, well, you missed a step here. Probably not, but it's possible.
That both administrative and judicial parliament, it's a sacred precedent that such a high superior court, when it sends it back, it is implied direction that you do it with positive context. That is a reference to the court. That's it,
Right.
all of the work, not being on the common side.
Right.
When it's such a court like Supreme Court, it's implied that you don't want to do your job, please
Right.
do it as we.
Right.
That's one end.
Yeah, I think so. Yeah, I think so. But when you are talking about a procedural piece that's missing, you can see in that case it is very possible to give the procedural fairness or take whatever step was missing, but if there's a proper weighing of the evidence, you could easily still have the same substantive result. So. Excuse me.
Because after all, she was the
Yeah, then you'd want to just look at the legal test, weigh the evidence, just look at the evidence as it is, as opposed to, but do it in a way where you, in this case, hear all of the submissions. This is a very, this would be like a Section 7 almost kind of case where her life, liberty, security of the person, it's very serious. You'd want to make sure you'd have all of the submissions before you deported someone, especially when they had 4 kids still here in Canada.
In later ways, Canada will essentially come, produce children, and get control forever. That's what the exact word of the immigration officer are. Can Canada afford to have this industry?
Right.
Now, remember that when it comes to admin law, you're not really questioning the statute. You're questioning the decision. Whether you believe the statute isn't fair, that's the government's prerogative to pass that law. That could be an issue from a constitutional perspective. In a constitutional exam, you would challenge that this act, this law violates our Constitution. From an admin law, you're really looking just at the action of that particular individual and how they applied this law to this person and how they violated their rights.
Yeah, that's a good point. Okay, so the 5 factors in a little more detail. Number 1, the nature of the decision being made and the process followed in making it. What the court's looking at here is this the type of case that requires the court-like adjudication, or is it more discretionary or regulatory in nature? Meaning that if you have a more formal process that's more court-like, you might be able to argue a higher level of procedure is required. More discretionary kind of a scheme, you might be able to say more of a moderate or lower level procedure would be appropriate. Number 2, the nature of the statutory scheme and the terms of the statute pursuant to which the body operates. Does the statute provide procedures? If they're not expressly stated, well, what can be inferred? You're assuming, actually, if you're looking at Baker here, you have to assume the statute hasn't been specific, but could you also take some kind of context from the statute? Does it tend to offer a very high level of protection, perhaps in other areas? You can make that argument. What could be inferred in this particular case? Is there a right of appeal or review provided by the statute? Is the decision intended to be a preliminary one, or will it finally dispose of an individual's rights? If it's a final decision, you're going to have a higher level of procedural fairness. If there is a right of appeal, you could argue again, you want to have a higher level of procedural fairness and greater detail, because how is the appeal level going to be able to do their job if, for example, there are no reasons? It's hard for them to be able to do anything with a decision that's not clear. Is the decision meant to be of a general application, or will it primarily affect a particular individual? The importance of the decision to the individual, this is the 3rd factor, or individuals affected. So the more important a decision is to the lives of those it affects, the higher the level of procedural protections mandated by common law. Number 4, the legitimate expectation of the person. Legitimate expectations sometimes of a particular process will likely result in that process requiring a certain level of fairness. We looked at some examples of that yesterday. And then number 5, the choice of the procedure made by the agency itself. This is where the court actually gives some level of deference to the tribunal, realizing that tribunals can make up their own rules and procedures, and they do so in order to be able to run efficiently. So if the agency has chosen a specific process, the court is going to turn its mind and say, well, they set this up for a reason. Let's give them some level of respect for doing that. They probably had cost, efficiency, etc. They turn their mind to it. And again, the tribunals are supposed to be the experts in these various fields. So let's give them some deference because they know how to use their resources in the best way. So you should consider these factors when they're considering what fairness looks like. Okay, a little more detail on each. Number one, that nature of the decision. Decisions that are considered, now we're going to see this language again, judicial or quasi-judicial in nature are likely to demand more extensive procedural protection than a pure administrative decision. This was, Madame Justice Laura Dubé who wrote this decision, and she put it this way: the more the process provided for, the function of the tribunal, the nature of the decision-making body, and the determination that must be made to reach a decision resemble judicial decision-making, the more likely it is that procedural protections closer to a trial model will be required by the duty of fairness. Okay? So if you're starting to look like a system that's, for example, like a criminal trial with the maximum procedural protections, probably going to require more fairness in the situation. A little more on number two, that nature of the statutory scheme. Again, pay close attention to the legislation itself that created the tribunal, that created the process. Fairness requirements, if you look at the entire statutory scheme, maybe you'll see that there are very minimal fairness requirements within it. And it might support an argument that a very limited, minimal procedural fairness is required. Remember again, investigatory procedures are not normally even subject to the duty of fairness. More procedural protection is required if there is this second level of procedure envisioned. So if there is internal appeal, like Mr. X yesterday, so you're still within the fiscal tribunal, but within that there is an internal appeal. Well, in order to allow for meaningful participation in an appeal, you need a certain level of procedural fairness at the lower, at the court of first instance, or the hearing at first instance. The importance of that decision, again, to the individual, well, most people, no matter what the situation is, are always going to feel like the case is important to them. Whether it's a license or it doesn't have to be at the level of deportation, people losing their employment, their livelihood. Example is the Kane Case Board of Governors, UBC. The court found that a high standard of justice is required when the right to continue one's profession or employment is at stake. So here's a great example where we were just talking about maybe the charter doesn't have that economics, Section 7 can't be used for economic rights. But here we have a case that says a high level of procedural fairness is owed when you're talking about someone's livelihood. Okay? But again, this is only where you wouldn't have that statute being really clear. Okay? You don't need to use the charter in all cases. Legitimate expectation, again, we spent quite a bit of time yesterday on that. A person might be led to understand that he or she will be afforded a particular procedural protection, such as an oral hearing, before a decision is made. Legitimate expectation began as a threshold inquiry, but in Baker, the court subsumes this within the concept of the content of the duty of fairness. So it's a little bit uncertain how you're going to use it, but I don't get too hung up on it because it's easy to just consider it at both points. legitimate expectation of procedural protection may arise out of the conduct of the representations, promises, undertakings, past practices, current policy of a decision maker. In the Mavie case, we'll look at that in a few more slides as well, a more recent case, where a government official makes representations within the scope of his or her authority to an individual about an administrative process that the government will follow, and the representations said to give rise to legitimate expectation are clear, unambiguous, and unqualified, the government may be held to its word, provided that the representations are procedural in nature and do not conflict with the decision maker's statutory duty. Proof of reliance is not a requisite. Okay? So that's an interesting statement. So you don't have to show that the person actually relied on it, although if they're raising it, you know, they've probably relied on that promise. Again, a reminder that this is all about the promise of a procedure, not promise of a particular outcome. And we talked about that yesterday with the Mount Sinai case and how they use the argument of promissory estoppel. That's fine, but legitimate expectation doesn't apply to a substantive outcome. Number 5, the choice of procedure made by the agency, a little bit more about that. The content of the duty affects more than just the person whose rights and privileges are at stake. It also affects the decision maker, who may be required to make decisions in many other cases, and those affected. So you need a workable standard of procedural choices that serves the needs of the entire community. So this is where, again, the court is going to give some deference and assume that this tribunal, this expert body, has turned their mind to why they've chosen a particular procedure. They're serving a whole community, not just each individual. The court noted in Baker the analysis of what procedures the duty of fairness requires should also take into account and respect the choices of procedure made by the agency itself, particularly when the statute leaves to the decision maker the ability to choose its own procedures, or when the agency has an expertise in determining what procedures are appropriate in the circumstances. While this, of course, is not determinative, important weight must be given to the choice of procedures made by the agency and the institutional constraints. In a JR situation, an agency can educate the court as to why they have the processes they have. And that does happen where you'll have often 3 separate parties in a judicial review. You'll have perhaps the 2 parties, for example, in a human rights case, you might have the person claiming they were discriminated, whoever allegedly discriminated against them, and then you might have a representative from the Human Rights Tribunal themselves, the decision maker. Because don't forget, what's being reviewed is the decision of that decision maker. Now, the role of the decision maker or the tribunal is not to go in there and argue for their decision. That would be inappropriate. But the role is to just assist the court. Sometimes the court doesn't even ask that counsel anything. They're like, oh yeah, we know how it works, no problem. But in some cases, they may be there to say, well, let me tell you about how our system works. Or, for example, in the world of accident benefits insurance law, you might get a panel that doesn't know anything about that area of law. Your role is to just assist the court, not say, oh, our arbitrator made the best decision and here's why. That's the party's job. They make that argument. Okay? So it's interesting. You might have 3 separate parties or counsel there in a judicial review. Okay, so we're going to take a break in a sec. I'll just, before we start talking about some of the particular issues, but we can take, now that we're going to look at some of the specific procedures, you could take most of them and put them into one of the 2, remember those common law and natural justice categories of the right to be heard and that right to an unbiased decision maker. And very loosely, and there could be others, under the right to be heard, we're going to look at procedures such as the notice you get, disclosure, oral hearings, timeliness, calling evidence. under the right to an unbiased decision maker, we're going to look at biased situations with an individual's conduct, so the bias perhaps of the actual decision maker, and then bias that's more institutional, bias that has to do more with the tribunal itself and how independent is the entire process. Okay, so let's take a break. And are we going to do, should I go in with the specifics and then we'll do an exercise before lunch? Yeah, okay. Okay, so take a 10 or 15 minute break and then we'll get through some of these specifics and then before lunch we'll leave you with we'll do an exercise together. let's get back to it. All right, so now we're going to look at some of this is probably the most concrete, I would say, section of all of admin law, because it's really nuts and bolts procedures, easy to conceptualize, easy to kind of wrap your head around, what the scope of what might be fair in the different categories. So again, I have these two categories, or the book also puts all of the fairness principles roughly into two categories of these. It goes back to the common law, natural justice. The two principles, there's a right to be heard and this right to an unbiased decision maker. So first we'll look at some of the specific procedural components that might fall under that right to be heard. And first is notice. So notice really is the most basic aspect of the duty of fairness. It's the starting point for participation in any decision-making process. It involves types of questions. So when you're looking at whether the particular notice in your fact scenario was fair or not, or fair enough, who is proposing to make a decision? What is the nature of the decision? When is the decision to be made? Where will the decision be made? Why is it being made? And how will it be made? So if you're involved in some kind of administrative hearing and you're receiving notice, and you're the person who needs to respond, you want to have those basic questions answered. And the reason for that is so you can properly, or your client can properly respond. The requirements often set out in a tribunal's rules of procedure or the legislation governing the hearing procedures. So very often there'll be a standard form for notice, that the tribunal will use, and something you can, that they will print off or that's available online. So hopefully the ideal situation is the notice will be somewhat standardized. But if it's not, then you want to look at, does it have enough information? The other aspect of notice is, was it done in a timely way, in the sense that did it give the parties or the recipient enough time to respond? And there's not necessarily an automatic formula there. There might be a specific rule in the statute. So here's notice that there's going to be a hearing. You have 30 days to respond. You can see the other extreme. If you were to receive a notice that said you must respond within 2 days, or some kind of action will be taken against you, or some kind of rights removed, obviously a few days or maybe even a week might not be enough, but there's no formula. You have to look at the context. So was it timely? Was it sufficient? Did it provide enough information to allow the recipient to make an informed response? So when you are looking at that in a scenario, that's really the kind of argument that you're making. And you can be creative about how you respond, depending on which party you're representing. The overarching requirement of the duty is the idea of reasonableness. So the general rule is that notice must be adequate in all circumstances in order to afford to those concerned a reasonable opportunity to present proofs and arguments and respond to those presented in opposition. Notice is also an ongoing duty. So it arises prior to making a decision, and it continues throughout the entire decision-making process. So if there are other requirements along the way, perhaps there's a pre-hearing, perhaps there's a settlement conference, perhaps there's deadlines for disclosure or exchange of information. That notice continues right until the end of the process. A party is entitled to participate meaningfully in the decision-making process, and in order to do so, they have to be apprised of all the relevant issues along the way during a hearing. Disclosure, another procedural requirement. Disclosure is a common concept in the context of criminal law, and the big case there, if you haven't done the criminal course yet, is Stinchcomb, Supreme Court case that held that the Crown must disclose all relevant material to the defense in a criminal prosecution, but the Stinchcomb principles do not apply in the administrative context. So you take Stinchcomb as the high watermark. Okay? In a criminal context, disclosure is also an ongoing obligation. If you get all of a sudden a new piece of evidence that's relevant, even if you're not going to use it, you hand it over, and you keep handing it over as new things come along. The threshold is not as high in administrative proceedings, and it's not, again, going back to the proceedings are supposed to be more cost-effective and efficient. So bombarding the other side with every document just might not make sense. In the May and Ferndale Institution case, the duty of procedural fairness generally requires that the decision maker disclose the information he or she relied upon. The requirement is that the individual must know the case that he or she has to meet. Okay? So slightly lower threshold, but again, context specific, and a statute might very well set out what must be disclosed, when it might be disclosed. Some tribunals might not make you hand over all the actual documents, but to be more efficient, perhaps you give a list of all the documents that might be relevant to the other side, and you exchange just a list first. Okay? It's very tribunal specific. The question is not whether disclosure is required in administrative proceedings, but how much is required in a particular proceeding. Again, you want to look at the tribunal-specific rules, possibly the SPPA. Courts have held that some circumstances, such as professional discipline and maybe the possibility of a loss of livelihood, are going to require a high level of disclosure. This disclosure is balanced with the need of authorities in particular circumstances and also the rights of other persons. So, for example, parole hearings, prison discipline cases, there might be concerns that are raised for the safety of informants, identities, maybe the use of other information from proceedings like criminal proceedings, wiretaps, search warrants, sensitive security type of information. Those are other factors that are going to be considered. Information can be vetted by a court to determine if its materiality and relevance and may be disclosed only to counsel. So that's always a possibility as well, that the tribunal, the decision maker, might do a kind of private review of the material in order to determine whether it should be disclosed or not. The duty of fairness is satisfied if a party has sufficient information to make informed submissions in regard to a particular matter. Okay? And again, you look at the seriousness of the type of case, and that will help you determine or make an argument for how much disclosure is going to be required. Oral hearings are often demanded. Everyone wants their day in court, but they're really actually seldom required. They're not always necessary to be able to reach an informed decision because they really add a huge level of delay and expense to proceedings. When will the common law require that an oral hearing be provided? Well, we talked about the Singh case, when the decision depends on findings of witness credibility. Okay? So if you have a case that will turn on someone's credibility, you're going to need an oral hearing in that type of case. So we looked at the Singh case. The court held that a person claiming convention refugee status was entitled to an oral hearing because making their argument about having a well-founded fear of persecution, it would be hard to make that argument on written submissions. Singh was decided under both Section 7 and 2E of the Bill of Rights because in that case it was a federal statute. And that was a case where, remember, the legislation actually did not provide for an oral hearing. It didn't offer it. So where legislation does not preclude an oral hearing, however, recourse to constitutional and quasi-constitutional is not going to be necessary. I know I'm kind of hammering this point home, but just really want to make it clear where if the statute has a gap, it doesn't say you don't get one, then you can use, here we go, you can use a common law might require that an oral hearing is held. The right to be present, and again, this list I'm giving you of specific procedures is not an exhaustive list either. Things can fall in, other things can be added, and sometimes items can fall into both categories of unbiased decision maker and right to be heard. But there is a right to be present through your hearing process. So no part of the hearing should take place without all the parties present, unless perhaps someone has voluntarily given up that right. That's going to be a little safer, and if someone's represented by counsel, then we've had hearings at FISCO where sometimes the applicant doesn't attend for all 4 days, often because they can't take 4 days off of work. But it's a right. Definitely the decision maker should not proceed without one of the parties there. The other times where a tribunal may proceed in the absence of a party is where you have had proper service, so proper notice, but someone just doesn't bother showing up. A party continues to disrupt a proceeding. Someone walks out in protest, so that would be voluntary. Or very rarely, evidence of a particular sensitive nature, but yeah, I can't think of too many cases where the actual parties themselves wouldn't be able to participate in that. The right to counsel, we talked about this as well. There is no right to counsel in the context of administrative proceedings, but it is a constitutionally protected right under Section 10B of the Charter in terms of situations where there's arrest or detention. But the right of representation is often set out in the legislation itself. So the statute will let you know if you can bring a lawyer or a representative, and what kind of representative. Probably more importantly is around the non-lawyer representative. You want to be clear about what will the tribunal allow in terms of just the layperson. Does the person have to be licensed by the Law Society, meaning lawyer or paralegal in Ontario? Can you bring a family member? Sometimes you'll see a rule that says you can bring a friend or a family member as long as they're not getting paid. And that's a bit of a consumer protection issue. So they don't want people who are not licensed paralegals or lawyers offering legal type services to people. So you want to bring a friend who's not getting paid, no problem, but not just Joe Blow off the street who's charging you. Again, that's a very tribunal-specific, usually kind of rule about who's allowed to represent. In the, just going back a paragraph there, the constitutional protection for legal representation, the BC Attorney General and Christie case, the court noted that the right to counsel was understood historically as relevant only in the context of criminal law, rather than something required by the rule of law itself, concluded that there was no general constitutional right to counsel, but it did leave it open to be recognized in some specific and varied situations. So again, I would say there is some wiggle room there to make an argument if you have, let's say, a deportation kind of case or a livelihood loss of license case, or where maybe a tribunal where there's going to be a possible very high fine against your client, right? Something that would be almost at the level of a criminal proceeding, right? Where the consequences are high, you have a better chance of making an argument that you may be able to say you have a constitutional right to have a lawyer. Not have that lawyer paid for, but at least have a lawyer present to represent you. The issue ability to exercise the right of legal counsel is usually more of an expense problem. The court acknowledged this in rejecting the existence of a general right to counsel and considered cost to be the primary reason for denying the existence of this constitutional right. The exception, though, to this is where the deprivation of life, liberty, and security of the person is at stake. Principles of fundamental justice may in some cases require the provision of counsel in administrative processes. Okay? So threshold is high, but the door has been opened to have counsel, and in that GJG case, have that counsel even paid for. The right to call evidence and to cross-examine witnesses. The right to call evidence and cross-examine is really normally part of a oral hearing. It's not an absolute right either, but tribunals often have their own rules around this. The SPPA also has some limits. The SPPA has a clause that says an adjudicator can allow questions that are relevant, and the adjudicator can also control the process. So, for example, yes, you have a right to cross-examine, but if your questions are starting to get repetitive and you're wasting the tribunal's time, the adjudicator can then, by virtue of the SPPA in Ontario, can say, okay, move on. You've asked that question, move on. So that's more about controlling the process. Again, each tribunal might have different variations on what this questioning looks like, and that would be your starting point. What does the enabling statute say? So the workers' compensation system, the appeal tribunal in Ontario is WYSIAT, and they allow for something called cross-questioning. They call it a little bit different. And the Information and Privacy Commission, witness questions can actually be directed through the adjudicator themselves. Information and Privacy Commission.
Commissioner.
I think is it
Commission?
Commission or Commissioner? Well, he's a commissioner. Commission. It's the Workplace Safety Insurance Appeals Tribunal. It's the appeals version of what we call Workers' Compensation Board, but it's not that anymore. It's the appeal level of WSIB. Again, you're going to see the general principle here. When in doubt, parties have to have a reasonable opportunity to present their case and respond to their case. So that's when you're looking at a fact pattern and you're deciding what level of procedure is appropriate, you start with that general rule. Okay. So everyone has to be afforded at least a reasonable opportunity to present and respond to their case. But it's going to look different case by case depending on the circumstances. The Innisfil and the Vesper case, Justice Esty emphasized that the right of cross-examination is not to be withheld on the basis of judgment by the tribunal that it is of limited utility. So just because the tribunal thinks it's of no use shouldn't mean that you don't get a chance to cross-examine. The decision to exercise the right is solely that of the holder of the right. He, of course, must exercise it at his peril, as is the case in any administrative or judicial proceeding where such a right arises. So it would be hard to consider or to contemplate a situation where you've determined that an oral hearing is fair, but not give the person a right to cross-examination. The two would have to go hand in hand. Timeliness and delay. So administrative decision makers are not usually under specific statutory timelines for holding hearings and making decisions. Okay? So the principle behind all tribunals is to offer this faster service than the courts, basically. But very few of the statutes hold the decision makers to a strict timeline. You must issue a decision by this day. The process must be complete within X number of days. And there is no charter right to have an administrative matter heard or determined within a reasonable time. There is no equivalent to the right to trial within a reasonable time. So Section 11B challenges for criminal cases. If you don't get your criminal case heard within a reasonable time, that case might get thrown out. There is no equivalent in the administrative world, which is interesting. Even though tribunals are supposed to provide more efficient, less formal, less expensive justice than the courts, it's not always the case. I say often not the case, it's not always the case. And this was challenged in the Blanco case that we talked a little bit about yesterday. Blanco in British Columbia, the Human Rights Commission, former ministry in a British Columbia government, sought an order to stay a human rights tribunal proceeding against him because it had been going on for 30 months and it still hadn't been completed. During that time, his political career came to an end. He was dismissed from cabinet, expelled from caucus, and suffered from depression. The majority of the Supreme Court concluded that in some circumstances, delay in the administrative process might rise to the level of a deprivation of life, liberty, and security of the person under Section 7, which would violate the right if not in accordance with the principles of fundamental justice. In addition, the majority concluded that undue delay in an administrative proceeding might impair the fairness of a hearing. So this is a really big new step and conclusion, opening the door for future cases in terms of delay. And the court said, and it could result in abusive process if the fairness of the hearing was compromised. However, the majority of the court concluded that the delay did not infringe Section 7 or the duty of fairness in Blanco's case. So they contemplated it, but found that the facts of his case didn't meet the test. The majority of the court dealt with the matter solely on administrative law grounds, and they set out 3 considerations that had to be balanced in considering complaints of administrative delay. First, the time taken compared to the inherent time requirements of the matter before the particular administrative body, which would encompass legal complexities, including the presence of any especially complex systemic issues, factual complexities, including the need to gather large amounts of information or technical data, as well as the reasonable periods of time for procedural safeguards that protect parties or the public. So they're going to look at the time taken, again, context specific. Very complex case, they're going to say, well, you know what, maybe 30 months for a complex case, maybe it's reasonable. Secondly, the causes of the delay beyond those inherent time requirements of the matter, which would include consideration of such elements as whether the affected individual contributed to or waived part of the delay, and whether the administrative body used as efficiently as possible the resources it had available. This is very similar to what is done in a criminal context. So if your case, perhaps criminal case, has been before the court for several years, but that's because perhaps the accused person asked for adjournments, wasn't prepared, the court will look at what's the reason for the delay, and they'll do like a little balance sheet. Okay, Crown Attorney caused this much delay, but the accused caused this much, and they'll do a little formula, and they'll look at what the actual reason was, not just the number of months or years it's taken something. And then the court looked at the impact of the delay, considered as encompassing both prejudice in an evidentiary sense, but also the harms to the lives of the real people involved. This may also include a consideration of the efforts by various parties to minimize negative impacts by providing information or interim solutions. Okay. So again, Blanco, it opens the door for delay. It didn't find that they didn't use Section 7 in his case, but they did have a good discussion about what will the court look at in terms of administrative delay in the future. The minority court emphasized the importance of a contextual inquiry into the problem. In the context of administrative proceedings, there were important interests apart from those of persons complaining of delay that had to be considered. In Blanco's case, the interests of the women who complained of the sexual harassment. Staying the ability of the Human Rights Tribunal to hold the hearing would deny the complainants their right to have their complaints heard. Thus, although they considered that the delay in Blanco's case constituted an abusive process, the minority of the court considered that a stay of the proceedings was inappropriate and would have made an order to expedite the proceedings instead. Following Blanco, it's clear that delay in providing a hearing or presumably rendering a decision may breach duty of fairness and may even rise to the level of a charter breach. But the normal remedy for delay is likely to be an order in the nature of mandamus. So again, this is going back to when you're pursuing this, what's your remedy going to be? The only thing you can really get is mandamus, an order for someone to take action. So what would that look like? It would look like, decision maker, I order you to write that decision. Right? If someone is taking extreme delay in issuing a decision, it's very hard to force someone to write a decision. So there might be this order, but how do you force someone to issue it? Yes.
Like you don't mind if you feel that normally in the case of the sexual harassment, should human rights, should human come into play, or is it normal complaint to the police authority and the person is charged by the police? That's what is not.
It depends on the actual behavior. Sexual harassment could potentially be a civil suit if the behavior involves some kind of physical touching. It might be a criminal act. It would have to fall within sexual assault then. So it really depends on the behavior.
But what is human rights, human come into play?
Because the Human Rights Code in Ontario and BC, they're very similar codes. Actually, the behavior of sexual harassment falls within the Human Rights Code. So it's not only discrimination on the basis of sex, but also
Its own section.
it's its own special protection.
So that part is understandable, that they some gender like females are discriminated, then it should fall. If it's a harassment or sexual advances, that comes under modesty, operating modesty, that is specifically it's a criminal law.
No, it's an overlap.
There
It's not-
depends on the behavior.
Yeah, it could be an overlap, and one, and the criminal system has completely different evidentiary and burden rules than other systems, right? So you could have a complaint against you in your workplace, and that may or not turn into a criminal matter. But now you're dealing with maybe an employment matter, and maybe you're within the type of employment that's a public employment, and a decision is made, and it's an administrative decision, so now you're in the admin world. And at the same time, maybe the complainant is also suing you, in the Human Rights Tribunal, or maybe a private lawsuit. So there's an interaction of different types of laws and procedures that could happen from one conduct.
It may be the complainant, I'm going to say herself, to somewhat stereotypical, but in most cases it is, but it may be the complainant herself who decides what does she want as a remedy. If the behavior fits into the criminal definition of sexual assault, she may want that person charged depending on if that incident or behavior, maybe it was criminal and she wants charges laid. In some cases, if the behavior is long and ongoing and you're in a workplace where that's just really poison kind of workplace, you might want a human rights approach because you don't want criminal charges against one person. You want the entire workplace. The remedies that are available under human rights are more far-reaching, and they could change workplace policies. That person might get moved to another position. There are a whole series. So I think the person complaining, again, will think of what remedy is appropriate and decide. And you could be potentially in both of those worlds, I guess. You could be in criminal and human rights at the same time. Human rights will likely say, finish your criminal case first, for the same reason. We don't want to have some conflicting result. Finish the criminal charges first, and then come back. Yeah, the duty to give reasons. So here you're going to see a little bit of overlap with what Deb will talk about in substantive law Thursday. But historically, there was no duty on an administrative decision maker to actually give reasons. But since Baker, this has changed. Here you have the court stating, in my opinion, it is now appropriate to recognize that in certain circumstances, the duty of procedural fairness will require the provision of a written explanation for a decision. The strong argument demonstrating the advantage of written decisions suggests that in cases such as this, where the decision has important significance for the individual, when there is a statutory right of appeal or in other circumstances, some form of reason should be required.
I think we should qualify that. I think you have to have a very clear understanding that there's a difference between a decision and reasons. Reasons, they're not the same. So you apply for a license and I write you a letter saying denied. That's my decision. But I don't say anything else. I don't actually give you my reasons, right? Typically when you see a decision, you would expect, a clarification of what the issues are, what he said, what she said, what I decide, right? And it's not always like that in the admin world. Sometimes you just get a decision and either you don't get reasons or sometimes you get very little reasons. Denied because you don't qualify according to section blah, blah, blah of the statute. Done. And that's it. That's all you get. So this is really important and may come up in your NCA.
Like visa applications from outside of Canada.
Right.
Canada, they have a checklist, 15, 16 grounds. They will just tick mark. One or
Check mark.
two, three.
Check mark is the reason.
Check mark.
Right.
Even if it may not be perfectly applicable.
Right.
Check mark.
Right. And that ties to what Liz is about to say next.
Yeah. So reasons are not required, though, for all decisions, but they are required in certain circumstances. And I would say more and more the case law is moving more towards at least having some reasons, no matter how minimal. Even if it is, as you said, a checkbox might be okay depending on the circumstances. So reasons are required if a particular decision has important significance for the individual, because public actors demonstrate respect for those affected by their decisions by justifying the decisions they make. Reasons are also required if there is a statutory appeal process. So again, that helps the next level make a better assessment of the original case. It's difficult, if not impossible, to determine whether to appeal a particular decision and which arguments to make if there's no explanation provided for that decision. Baker leaves open large discretion for courts to require reasons. It contemplates flexibility in complying with the duty to give reasons, to provide some form of reasons, and as a result, reasons may vary in their length and their formality, again, depending on the circumstances. There's a wide variety of quality of submissions and decision makers. In Baker, the court accepted that those informal notes that were prepared by the immigration officer actually satisfied the requirement. In that case, that person's notes qualified as reasons. Two main concerns on procedural review. There may be a failure to provide reasons in circumstances in which a court says that reasons were actually required. And then questions may arise as to the adequacy of reasons in certain circumstances. Now, it's this second point that will have some overlap into the area of substantive review. In a very, very basic way, the duty just to give reasons is a procedural fairness issue. When you're looking at how adequate the reasons were, that's where you start trickling into substantive issues. The court looked at the duty to provide reasons in the Newfoundland and Labrador Nurses Union case. The court emphasized that reasons need not be provided in all cases, asserted that Baker does not establish that the quality of reasons proffered in a particular case is a question of procedural fairness. So if you have some reasons but they're pretty crappy, that's not a procedural fairness issue. Might be a substantive issue, but not procedural fairness. On the contrary, the threshold for satisfying the requirement to provide reasons is very low. It strikes me as an unhelpful elaboration on Baker to suggest that alleged deficiencies or flaws in the reasons fall under the category of a breach of fairness and that they are subject to a correctness review. If there are reasons, then there is no breach of fairness. That's a very kind of oversimplified approach, but that in the very basic essence. Any challenge, though, to the reasoning or the result of the decision should be made in the substantive review or the reasonableness analysis that Deb's going to look at on Thursday. In that nurses union case, again, it was Madam Justice Leroux Dubé recognized that in some circumstances the duty of procedural fairness will require some written reasons. The appellant nurses union argued that the labor arbitrator, who had provided some reasons, nonetheless provided reasons that were so inadequate that they rendered the decision-making process unfair, thus engaging the correctness standard of review. The Supreme Court disagreed and held that where reasons are provided, the adequacy of the reasons is not reviewable as a matter of procedural fairness and is not a freestanding ground of review. Is that clear? Do you want to just digest that for a minute? So in that case, there were reasons. They were really bad. But the fact that there were reasons there said, you know what, in the area of procedural fairness, we're not going to look at the quality of the reasons. That's not part of our procedural fairness review. We might look at that in a substantive review, but not in terms of whether it was procedurally fair or not. So in other words, yeah, question?
Is a reason, in this case, is that a case where female nurses, their pay was a bit lower compared to the male in the hospital, and they won the case, but the government said sort of public deficits because to provide the remedy that
Remember what that one was? Was that that?
I'm not sure how it's related to the duty to give reasons.
Oh, you're just wondering if that was the case? Or
Because
not?
if those were the reasons,
I thought the reason was like public deficit, and the reason was not good enough.
there's a difference between the reasons not good enough and from a procedural fairness perspective, you get a decision and there's no reasons. How do you deal with that?
I don't
right?
think, you know what, we'll check on the break. I don't think that's the same case. I think this was more around the arbitrator, not the reason itself was not a good reason. It was just the way they were written was not very detailed, incomprehensible. It's more what this point is, when you get a decision and you look at it and you can kind of barely understand it, and it seems to be missing, oh, I made 5 arguments and I only see one of them here in the reasons, and I think that's more what the principle is addressing. But let us take a look at that at the break. Off the top of my head, I don't remember if that was the unequal pay case. So in other words, again, where the applicants are alleging that there's some deficiency in the reasons, the remedy is substantive review. Okay? And in the nurses union, that review was conducted. It was conducted as a separate part of the judicial review, not in the context of procedural fairness. Okay? Another case, the Alberta Information Privacy Commission and Alberta Teachers Association emphasize that courts are not to reformulate a tribunal's reasons in order to render them reasonable. It may sometimes be necessary to return a decision in order to allow a decision maker to provide reasons on a particular matter, thereby allowing the court to defer on an informed basis if the decision is actually reviewed after that. So that might be another option. If there were no reasons given, send it back, get the reasons, and then at least the court can review those reasons and then decide what Deb will look at. When you have those reasons, then you can decide, oh, are they reasonable? Are they correct? What standard do we use? It's a whole other analysis. Okay? but you don't do that analysis under the category of, did I get procedural fairness or not? So we're still in that first part of the checklist. We're not in the substantive review. So all of this to say is that future cases probably need to clarify this point, because there is still this overlap and there is a little bit of gray area for the duty to give reasons. At least this much is clear: a wholesale failure to provide reasons will constitute a breach of the duty of fairness. Okay? So Baker seemed to give a little flexibility that said, well, not in every case, you might not need reasons. I think the cases that followed have been more clear to say, if you get nothing, as Deb, the example that Deb gave, license denied, if you get no reasons, that's a breach of fairness. Okay? Following the Newfoundland Nurses Union, however, the court will not be concerned with how adequate or sufficient the reasons are. The focus will be on the substantive question. Or that's when the court will look at that. Do the reasons allow the reviewing court to understand why the tribunal made its decision and permit it to determine whether the conclusions are within a range of acceptable outcomes? That last paragraph, that's what the court is looking at in the substantive review piece. Am I losing you guys? Is it? I feel I'm either losing you or you're getting hungry. Is that? Or maybe it's so clear that it's like, yeah, we get it. Move on.
It's going to be 1 point in procedural fairness. If you have a scenario where you get your application is denied and there's nothing else, you want to put in a sentence that says, and further, the duty to give reasons may have been violated in this case.
Right. That although the court in Baker may have said you don't always have to give reasons, recent case law says the absence of any reasons at all is a breach of procedural fairness. In this case, there are no reasons, so there is a breach. Consider what the remedy is. The remedy would be typically send it back to get those reasons. When you get those reasons, if they're still a mess, they're incomprehensible, or they're just not legally sound, then we're going to look at that, but we're going to apply a different part of the checklist. We'll apply a different analysis when you actually have some reasons to deal with.
Is it practically done that courts are sending back to the tribunal for the
Yes.
sort of,
Well,
usually time-consuming?
they have to send it back. How does a reviewing court assess this action without a proper decision and reasons? What's there to? They can't even go about assessing it. They have to send it back.
Then the time-wise, the way justice probably is the background substantive.
But what's the option? What else can you tell me? What else can a reviewing court do in such a situation? What are their options?
If the decision of the tribunal is not a speaking order, or if the tribunal is sketchy order,
Right.
then substantive review is an option.
Right, so substantive review to deal with the adequacy of reasons and whether they were reasonable or not. Yes, but then what? At the end of that, then what can the reviewing court do? It's judicial review. They're not giving you the correct decision. They're still stuck within these writs, right? Declaration, mandamus, certiorari, setting it aside. They're not replacing it.
Yeah. They just don't have that ability. Okay, we talked about this case, the Mavi case, a little bit this morning. This is one of the it's a newer case, and it's new to the syllabus this year as well. So we want to take some time to look at it and maybe read it. This case addresses what the duty of fairness, if any, is owed to residents of Canada who have defaulted on undertakings made to the federal government to guarantee the financial security of family members that they sponsored. So these are, again, it's an immigration case, but family sponsorship. So when you sponsor your relatives, you make certain undertakings that they're not going to go and use public assistance, you're going to financially support them, and the person sponsoring makes certain commitments. The proceeding was initiated by 8 sponsors whose relatives had received social assistance, and therefore they were in default of their undertakings. The sponsors, because what happens is the sponsors then have to pay back the social assistance that has been collected, or by the people that they've sponsored. They're financially on the hook for these people. The sponsors put forward that the enabling legislation, the Immigration and Refugee Protection Act, so again federal, vested discretion with the government to determine on a case-by-case basis whether or not to enforce the debt, and sought to avoid payment of the debt either temporarily or permanently. Binney, for a unanimous court, ruled that the undertakings are valid contracts and there is no discretion for the government to forgive the debt. However, the contracts are controlled by federal legislation, and therefore the enforcement of the contracts must import administrative law principles, including a limited duty of fairness. As set out in the judgment, the content of the duty of fairness includes the following: to notify the sponsor that the government will be pursuing a claim regarding the debt, so that falls under notice; to afford the sponsor an opportunity within limited time to explain in writing his or her relevant personal or financial circumstances that are said to mitigate against the immediate collection; to consider any relevant circumstances brought to its attention, keeping in mind that the undertakings were the essential conditions precedent to allowing the sponsored immigrant to enter Canada in the first place; to notify the sponsor of the government's decision. Okay, so that's the duty for ongoing notice, and without the need to provide reasons. Okay, so here we have stated no need for reasons. The court concluded that the duty of fairness was met with respect to all 8 of the respondent sponsors. Okay, so here we have a little bit of a diversion here of where the statute has been very clear that there is no need to provide reasons in this case.
This and the definition that there's no need for reasoning is within the context of a pre-existing contract between the individual and the
Right. Yeah, this is a really interesting case. So what you have is part of the program, the sponsorship program, is that you undertake or you agree to, right, to take care financially of the people you're sponsoring into the country. So you're right, you're making a contract with the government, you're making a promise, some sort of a contractual promise. And I guess because of that, the duty of fairness is a bit limited, because as well the impact is not just on you, it's on other individuals.
Right. And again, we have a situation here where you have a statute that's very clear. Right? So they're recognizing there's a limited duty of fairness here because the preconditions, the contract, you can call it a contract or the legislation, is crystal clear. There's no room for the common law to step in. Right? There's no gap here.
Right. Remember, the government has the prerogative to create programs and then to create acts to administer those programs, right? And there is a very limited sort of opportunity for you to borrow from the common law or from the charter or from the Bill of Rights to sort of argue that you deserve higher, better procedural fairness, right?
I think at first the government tried to argue, listen, these are contracts. Admin law doesn't even come into play here at all. Let's just look at the contracts. the court kind of gave a little and took a little bit away. The court does say, well, yes, they're contracts, but those contracts are regulated by a federal statute. It's not some private arrangement between private individuals. So admin law does apply. We're going to apply the principles, but in this case, minimal fairness, right? Because you do have very clear circumstances. Probably if the situation was, more around someone getting deported, maybe the situation was different.
Consequences more severe.
Yeah, exactly. Not merely financial, perhaps there would have been a different outcome. The other kind of interesting case, somewhat related to this content of fairness, what does fairness look like, is the Suresh case, and where the court applies the 5 questions from Baker. So again, another, if you have the time to look at it, see the application of these 5 factors. The background for this one was Suresh is a convention refugee from Sri Lanka, applied for immigrant status in Canada. In 1995, the government rejected his application and ordered that he be deported on the basis that he was a security risk. The Canadian Security Intelligence Service, CSIS, had claimed that he was a supporter and fundraiser for the Liberation Tigers of Tamil, ELAM, a terrorist group in Sri Lanka. The Federal Court of Canada upheld the deportation order. Following this, the Minister of Citizenship and Immigration issued an opinion that declared him a danger to the security of Canada under Section 53(1)(b) of the Immigration Act, and consequently should be deported. Suresh had been given an opportunity to present written and documentary evidence to the minister. However, he was not provided with a copy of the memorandum of the immigration officer, and consequently was not provided with the opportunity to respond to the memorandum. Due to this inability to respond, Suresh applied for judicial review on the decision, arguing that the minister's decision was unreasonable, the procedures of the Immigration Act were unfair, and the Immigration Act infringed Section 7 of the Charter, 2B, 2D, 2B and 2D of the Charter. The application was dismissed by the federal court. On appeal, the Federal Court of Appeal upheld the decision of the federal court, and then it was taken to Supreme Court. The Supreme Court found that Suresh was not owed a full oral hearing or a complete judicial process, but he was owed a level of procedural protection greater than that required by the Act, which basically was no protection whatsoever, and greater than that which he received. Specifically, the court found that a person facing deportation to torture under 53(1)(b) should receive a copy of the material on which the minister is basing their decision, subject to valid reasons maybe for not disclosing. So perhaps we would include Suresh also under the category of a disclosure type of case, where there may be security reasons why you might not give full disclosure to someone. Second, that an opportunity be provided for the person to respond to the case presented to by the minister. And furthermore, the refugee who is being deported has the right to challenge the information of the minister, including the right to present evidence. The court finds that because Suresh made a prima facie case that he would be subject to torture upon being returned to Sri Lanka, and because he was denied the procedural fairness owed to him by the Charter, the case should be returned to the minister for reconsideration in accordance with proper procedure. So again, another example, didn't get the proper procedure, go back and try again. This is a case where the Charter is able to step in because they found you have the Act, but the Act doesn't give enough protection. It might be specific, but it didn't give enough protection. Okay, so we're going to give you a little time to look at a scenario in a minute, but before that, so just to wrap up, what we've now completed, we're still in what does fairness look like, that's step 2, the content of the duty of fairness. Okay. So remember, if there's an enabling statute, that's where you go to find what's the content. If the statute is not a complete procedural code, or if there is room there to supplement, Then you move into the common law. And the common law basically has two aspects to consider, and we've now finished that first one, that right to be heard, and all the various elements that fall into that right to be heard. Okay? We'll have you take a look at a scenario and then probably break for lunch, or maybe
Yeah, well, let's
see.
do scenario and lunch together, and then when we come back for lunch, we're going to get through the second part, the right to an unbiased decision maker, because you know that you're getting a question on the NCA that has a bias issue. You're going to get a question probably that has a bias issue. It's inevitable, right? There's going to be some bias, some conflict, something that relates to either individual bias or institutional bias or that independence of that decision maker. So we're going to spend the afternoon focusing on that and make sure that you have a really good understanding of that issue. And I think the case scenario that we're going to ask you to look at together with lunch is the Law Society one? Or,
Yeah, maybe one of them might. Last Saturday?
yeah, maybe the Law Society and Martha? Or no?
Yeah. Not Martha, the
The
fair wages.
fair wages?
Yeah.
Okay.
Okay, so take some time to look at scenario number, so in your sample scenario booklet. Okay, so 3 is, this is substantive, right?
Yeah.
Okay.
I would either
So-
do the Law Society or the fair wages.
Let's
which is-
do both. Let's have them read both.
Okay. So the first one is pretty straightforward, and it's the Law Society one. Just
Scenario 4.
right, and that's really to get you to think about, when you have functions of investigation and functions that relate more of a decision-making and that interplay in admin law. And so spend not that much time on the Law Society scenario, that's scenario 4, and then take a look at NCA sample 2. It's the bidding under the fair wages policy. Now, don't prepare the memorandum, but, have sort of point form outline, and try to use the checklist or your own sort of roadmap to see how you would attack this question from a procedural fairness perspective only.
And keep in mind, we haven't got to the bias, there may be some bias issues there. We haven't quite got to that, but usually bias is pretty obvious. So you could, just point form, flag the issues. We've got through the procedural piece. If you see any substantive problems, we'll save that. We'll come back to that Thursday or Friday, and we'll look at it again. But for now, just pull out the procedural piece and how you might use the checklist, as Deb said, to actually answer the question. But don't take the time to formally answer right now. That's
So
fine.
should we add 15 minutes to lunch? Should we come back at 1:15 then?
1:15,
1:15. So,
Scenario 4,
The Law
which is Law
Society.
Society.
and NCA sample 2.
2. Yes.
One question was, in this checklist, we have to go first to labeling definition to find out
If you have it.
if we have it.
They may just give you a scenario without any statute.
Yes. And after that, if it is not there, we will go to SPPA.
SPPA,
Yeah, before going to,
General Procedural Code.
yeah,
Yeah, you could. You could mention the requirements of the SPPA.
yeah, before going to.
Yeah.
Someone else.
Yep. Good. Remember, sugar, carbs, fat.
That's everything.
By
Okay.
the time of the exam, there'll be
When I did my bar ads, we studied for 8 hours a day at Chapters. and the only immediate food was Starbucks. Oh boy, those 15 pounds took a long time.
Yeah, 15 pounds and $50 later, maybe. Okay, so we'll see you back here at 1:15.
You think I'm joking?
Okay, let's take up the Law Society scenario first, and then we'll see how our time is. Maybe we'll do a few more slides, and then the other scenario. So the Law Society, this is more of an essay-style answer, as opposed to not really a fact scenario. It's not saying you won't get something like this, but this is pretty straightforward. You probably get something a little more complex, I would think, on an NCA exam. But this is a good example of what we were talking about yesterday, those lines between tribunals or organizations that perform a multiplicity of functions. So maybe within one organization, you have investigation, you have prosecutions, you have the actual hearings themselves, and the kind of lines that need to be drawn in between those various, those kind of multifaceted types of tribunals and agencies. So the Law Society is a really good example, and one that you'll eventually come into contact with, of one of these kind of multifunctional, multifaceted agencies that performs a whole variety of functions in their mandate, right? But they are administrative in the sense that there is legislation that governs their conduct and the services that they provide. So let's look at that first question. Which of the functions described above are subject to the rules of procedural fairness and which are not? So this takes us back to the slides yesterday talking about the limits. Sometimes there are limits where procedural fairness does not apply. Which of the functions do require a level of procedural fairness? Yes. Definitely the hearing, okay, in front of a panel definitely requires procedural fairness. Yes. Sure.
One point of observation is the Law Society carries out random audits of law. That is arbitrary. It should be either all or sample or every. Random can be especially when the person who is deciding or decision maker are the peer students. So random can lead to a lot of
Well, that's interesting, but they're not the only regulator who would conduct random audits. And you could think of many reasons why the audits might be random, probably for efficiencies and just resources. Right.
Depends like the person whose accounts are being picked up on the rent check or the legal filer.
Okay.
I was singled out since all of them appear, so and so was part of the benches, so he made sure unless there is a procedure streamlined or randomly they are going to pick it up.
Well, randomly could be a computer program. Every person starting with a letter,
I agree with you,
See.
but everything can
But
be
do you
programmed.
think that matters? Do you think that the audit part, that phase, do you think that phase would attract procedural fairness? The audit phase?
It can be controversial.
But can it attract procedural fairness? From everything that we sort of covered today and talking about, the process where you have a process that looks like it's an investigation, and then you can also have a process that looks more like decision-making, which one of those would attract, more likely to attract procedural fairness requirement?
Because an audit is basically similar to what? That's right. An audit is similar to investigation, and so most of what we've heard is that an investigation at that preliminary stage, there's no decision yet, does not attract procedural fairness. Okay? Now, what you're talking about, let's say there was a scenario where it wasn't random and you could somehow identify, oh, I was singled out because of some particular person targeting me. Okay. Then that might be a bias issue, a different allegation down the road. But the very function of conducting an audit probably doesn't attract procedural fairness. Okay, yeah. Yes. Anything else? Any of the other functions? What about the continuing education programs?
That's okay, nothing wrong with that.
Yeah.
It's subjected to audit and now in that investigation stage, it doesn't mention oral hearing.
It doesn't, again, remember, investigation is just that. It's an investigation. So the audits and the investigations probably no,
Or maybe reply by instead of immediate investigation, co-opting the party being investigated. It could be a little more elaborate when you are drafting the rules of right. It says, we investigate complaints of malpractice brought by the clients and the lawyers.
right. So how it could play out is this. The general principles of procedural fairness would not apply to the investigation. However, if that case went on to go to a hearing and you were somehow disciplined based on the investigation, you would then argue, well, wait a second, this investigation was faulty for the following reasons, just like any poor piece of evidence. You know, it's not reliable evidence for the following reasons. But just because you weren't given the opportunity to provide response during the investigation, and I will say that a proper investigation does require some feedback from the person investigating. It might not fall into a requirement of procedural fairness, but a decent investigation, you should at least hear the other side. Otherwise, you're kind of wasting your time, right? You don't, how can you make a recommendation based on, you know, all the evidence if you haven't? But that's it's a different issue. It's outside of here. So your time to be able to respond, if you didn't get a chance during the investigation to respond, a proper hearing should give you the chance to give a response, right? Respond to the allegations that are made. I don't think with the education, you know, providing continuing education, there's probably not a lot of, that's maybe in the more of the policy work, probably not a lot of procedural fairness required in those tasks.
And also it is only an encouragement. It's only an encouragement.
Right.
That encourages
Let's see if I can bring up the answers for you.
What about what about the review of the files of the clients? Does it not involve the privileged issues? Secrecy of the responsibilities?
The audit, the random audit?
Yeah, right.
Well, when you are part of a regulated body, part of being that kind of professional, there are certain requirements that you agree to. If you are regulated, you're paying your fees, you have to adhere to a certain code of conduct. It's just like insurance agents, mortgage brokers, doctors, you know. So a random audit in itself is part of being a regulated profession. You have a code of conduct, and that's your responsibility to adhere to. So I don't, on the face of it, I don't see anything wrong with the audit piece of it. Yeah. Usually it would be a requirement. I know for, again, insurance agents, mortgage agents, if you get audited, you have to open your books to the auditor because they have to be able to check to make sure you're adhering to the regulation and the legislation.
Was client privileges and as well as maintaining the secrecy of the documents and professional
Concern over solicitor-client privilege with the audit. I don't think the information, in terms of if it's only used for the purpose of that audit, it's outside of the area of admin law for sure. But okay, so the legislative and policy decisions will not be subject to the rules of procedural fairness. When the Law Society makes binding rules and regulations that govern professional conduct, it's carrying out a legislative function, and they need not consult with the lawyers individually or collectively first. So even though it doesn't look like formal lawmaking, when they're actually creating those bylaws and regs, they're not actually required to consult. It's a good idea, but not required. when the Law Society establishes policies and guidelines about professional standards, we'll get that again. There's no requirement to consult with lawyers before making recommendations about changes to legislation or regulations, such as how much the government will pay lawyers to do legal aid cases or how paralegals should be regulated. Again, these are purely policy questions. So when you're approaching something like this or a fact scenario, look for those 5 limits, right? Something that's purely a legislative function, a policy function. Right? Audits and investigatory procedures are also largely immune, as they do not in themselves result in any binding decisions that affect the rights or entitlements. They merely consist of looking around. However, some minimal procedural fairness requirements would apply. For example, if an auditor or investigator insisted on searching a lawyer's bedroom at midnight and refused to provide an explanation or identify themselves, then that probably would violate the principles of procedural fairness. However, while auditing and investigating functions would require some degree of procedural fairness, auditors and investigators would not be required to comply with the rules of natural justice. Okay? So it's not to say people should be conducting these things in any way they want, but it doesn't fall within the scope of what we're looking at here in admin law. For licensing exams, professors would be required to use fair procedures in marking papers, and a decision to fail a student would be subject to a challenge if it was not made fairly. Similarly, if the Law Society refused to license a student to practice law despite having passed the exams, this would also be subject to a challenge. A hearing to determine whether to discipline a lawyer would require procedural fairness because obviously it affects the lawyer's rights. And of the functions that are subject to the rules of procedural fairness, which ones would be subject to more stringent requirements? And I think this one's fairly obvious. So of all of those functions, the hearing role, at the hearing to determine whether to discipline a lawyer would require compliance with the rules of natural justice. It's the only function involving a formal hearing before a tribunal of a quasi-judicial nature. So another way to say that, that's probably in terms of what amount of fairness, that formal hearing is going to require the highest level of fairness if you're looking at it from a content perspective. We'll post that as well, yeah? We'll
We
post
post
that,
it.
yeah. We'll post the answer as well.
Yeah.
Okay. Why don't we do,
Last time, the judicial or quasi-judicial, that means the matter has to go outside the members of the law.
no, it was more looking at the type of process. So remember in the Baker case, one of the factors is you look at the entire process, and the more formal the statute and the statutory scheme is, the more like a court case it looks like, the more of an argument you could make for a higher level of procedural fairness. Okay? If you have some kind of system that's, I don't know, loss of discretion, very flexible, not very formal, in that case you could say, well, that doesn't look really like a court, so we're going to say lower procedural fairness for these cases. But in this case, when someone's having a discipline hearing, that's a very formal procedure. It looks a lot like a court case. So they only meant it looks judicial, therefore higher level of procedural fairness. You could make a good argument there that probably need very good notice, lots of disclosure, maybe even an oral hearing because you want to hear from the lawyer. Right to, yes. We have a loss of livelihood perhaps there,
This
right?
issue will always be linked to know that people who are decision maker are peers, they're from the same group, competitive group.
Decision maker and the lawyer were from the same,
It's the same community, lawyers. Because
yeah.
the bench form part of the body, and most of the complainants are also opponent lawyers.
Well, the regulator, the person who's actually regulating isn't necessarily your colleague. they might be lawyers, but it's part of a regular, like the Law Society is its own beast, right? It would be like because I know this area the best, when an insurance agent has done something wrong, they appear before a panel, and that panel has one member from the insurance industry, one lawyer, and one layperson. They mix it up sometimes, but there is one person from the community because they know the area. So there wouldn't be a conflict there.
We also have some legal.
Okay, shall we move on to bias, or do they
No, I think we should
move on to bias? We'll do bias for a little bit, and then we'll get to the other scenario that you prepared for. So that second branch of procedural fairness falls under the right to an unbiased decision maker. And within this branch, we're going to look at the unbiased individual decision maker, the tribunal itself, and then kind of some related independence issues. Bias can stem from individual conduct, but it also can come from the institution. So the decision-making body as a whole maybe doesn't have enough independence, or sometimes it's referred to as institutional bias. Using the common law to justify a procedural fairness attack on the basis of insufficient independence is not likely to succeed where the statute creates an administrative regime, because the common law cannot prevail over a statute. I'll talk more about that when we get to the independence section. The independence argument could be based on a Section 7 Charter or Bill of Rights source, assuming that they would be triggered. Bias and independence. So administrative tribunals must be free from an appearance of bias. That is, a reasonable person must conclude that an administrative decision maker is sufficiently free of factors that could interfere with his or her ability to make impartial judgments, commonly known as the reasonable apprehension of bias test. Okay? So you want to highlight that sentence. That's what the test is called. This is derived from the natural justice principle. We have some Latin there, nemo judex in sua causa, or in the right to be judged impartially. Independence is one important indicator of whether there is an appearance of bias in an administrative body, although administrative independence is not required to be as strict as judicial independence. There are certain minimum requirements such as security of tenure, independent administrative control. However, administrative independence is not guaranteed under the Constitution and can be ousted by statutory language. So often, these boards and tribunals are created by statute. The very fact that they're created by statute goes to the fact that the law has contemplated there may be some relationship between the people making the decision and the government. Okay? That's what we mean by, is there enough independence? Or between the people making the decision and the ministry that governs them. So Ministry of Labor over Workers' Compensation Board or the labor tribunals. Okay? Ministry of Attorney General that governs Human Rights Tribunal. Once a court has determined that there has been a reasonable apprehension of bias, the decision in question must be void ab initio, as there is no remedy for the damage created by the apprehension of bias. Okay. So there's a lot of overlap in the text in terms of some of these terms, but some definitions. Bias is a predisposition or a prejudgment leading to a decision based on factors other than legitimate and relevant considerations. To say that there's impartiality is a state of mind free of bias. Independence is a state of complete liberty to decide a matter without outside pressure or influence. And we'll see some of the cases when you're talking about independence. It's compared to judges. Right? A judge who has security of tenure, they're not going to lose their job, never feels pressured or shouldn't ever feel pressured to decide in a certain way. Okay? They have security for life. It's not like some arbitrators who are only appointed 1 year, 3 years, 5 years at a time. That's just one example of an independence issue. Institutional or structural impartiality. Is there anything about the structure of the organization that might create the appearance of partiality in a substantial number of cases? And institutional independence refers to the relationship between the organization and the executive or government. It's freedom from government influence. So again, the general test for bias is the apprehension of bias. It must be a reasonable one, held by reasonable and right-minded persons applying themselves to the question and obtaining thereon the required information. The key case for bias, especially for individual bias, is the Liberty and National Energy Board case. It's still quoted today in arbitrators' decisions when issues of bias are raised. And a quote from that case is, "The apprehension of bias must be reasonable, held by a reasonable and right-minded person, applying themselves to the question and obtaining thereon the required information." In the words of the Court of Appeal, the test is, what would an informed person, viewing the matter realistically and practically, and having thought the matter through, conclude? Would he think that it more likely than not the decision maker, whether consciously or unconsciously, would not decide fairly? Allegations of reasonable apprehension of bias exist in two major forms: perceptions of individual bias and then institutional bias, or a lack of independence. And I think it's worth, I'll just go back, I think it's, again, worth noting that it is a reasonable apprehension of bias. It's not actual bias. It's not, the test isn't that you actually have to find conclusively that the person, the decision maker, is biased. It's how would it look from the outside? Regardless if that person can be a neutral and make a fair decision, but how would it appear from the reasonable person on the outside? If it would appear that the person cannot make an unbiased decision, then there's bias. You don't have to find that the person's actually been biased. Individual bias can show itself in a hearing in a variety of ways, and this isn't a conclusive list. Antagonism during the hearing. Okay. So maybe some kind of negative dialogue between the decision maker and one or of the parties. Some association between one of the parties and the decision maker, maybe a past relationship, past business relationship. Involvement of a decision maker in an earlier stage of the process. So the easiest example of this would be, let's say the decision maker or the tribunal, many of them have mediations, and if the mediation or settlement conference fails, you go on to your hearing. Well, it would be very rare to have the person who did the mediation also do the hearing. Because during a settlement conference or mediation, you're hearing things, you want people to settle, you're hearing elements of both sides of that case. If they don't settle, you can't just wipe that, those elements from your mind and go, okay, well now I'm going to be a neutral and decide your case. So that would be one example of some prior involvement in the actual decision or process. Number 4, a prejudgment by the decision maker. And that could come out by maybe, involvement on the record, statements they've made in the past to the press about a particular issue.
In the hearing room? Outside the hearing room?
About the parties or about the issue itself. Maybe they feel strongly about a particular issue or political party, or
even something simple as an arbitrator walking away from the hearing, going inside their office and saying out loud, "Oh, that applicant looks like a liar."
Right.
And it's, day one of the hearing.
Or a comment that, "Oh, I have this firm in front of me again. All the cases from them are fraud."
Right.
So just because it's come from a particular place,
So close
you've
mind.
already pre-decided.
Right. Any sort of statement that looks like the arbitrator or the decision maker doesn't have an open mind to really hear the case.
And then probably the most obvious one of the list is where your decision maker actually has some monetary or some personal interest in the outcome of the hearing itself. Right? That should never be the case, that they're deciding on something where that could actually benefit them. So I've listed some of the cases that are associated with each of these categories. They're from your text, so I'm not going to go into all of them in detail, but take a look at them, or at least note them, that if this comes up on in a fact scenario, that you want to say, at least make a note to one of these cases. So Baker would be a good example of that aggressive questions or critical commentary during a hearing. Right? That's where Baker argued that the duty of fairness was owed by the minister meant that the decision maker should be free from a reasonable apprehension of bias. And the court concurred and found that on the facts that there was bias in the case of that immigration officer who wrote notes on the file that were really derogatory against Ms. Baker. It would be hard to imagine how, after making those kinds of comments, how they could make a neutral decision after that. Okay, so take a look at these cases in each of these different categories. A little bit more about the prejudgment or an attitudinal bias. Someone who's predisposed towards a particular outcome. Has the decision maker or the organization demonstrated in the past a particular attitude towards the issue? Is it implicit in terms of the type of work done by the agency that previous statements ought not to automatically exclude the person from being involved in a determination of a subsequent similar issue? Perhaps somewhat in this category, but there was, I don't know if it comes up in a future slide, there was an argument made in the context of immigration law. It wasn't made successfully, but a party had done some stats on the individual decision makers at the Immigration and Refugee Board, and found, in 91% of refugee cases, this particular decision maker always voted for found for deportation, whereas this other decision maker in 80% of cases went a different way, and tried to use those statistics to say, clearly there's a trend, there's some patterns, and there's bias. Now in that case, the court didn't find that there was bias, but they didn't necessarily say that that approach couldn't be used. I think the evidence was excluded because they found the statistics themselves, they said it wasn't reliable, which is not to say that maybe they could have gathered some more evidence and found something that was reliable, but the use of these kinds of trends would more or less be trying to make a bias or a predisposed, an argument that one arbitrator was predisposed in a certain kind of case. Okay. I guess at FISCO, maybe someone could do stats and say, well, of the 100 cases Deb has heard, look, in 80% of the cases, she always found for the insurance company. Deb must be biased towards, just an example, she must be biased towards insurance companies, or maybe a particular insurance company. Then we have some other cases, some that talk about prior statements being made, some where there's comments made in the political context or personal advocacy. And again, what's the common theme there, what you should just take out, because it's not going to be, in every case where you've had a prior statement, that doesn't automatically mean bias. You still have to apply the test each time, the Liberty test. In that context, is there a reasonable apprehension of bias? Right? Those kinds of cases are really easy also to manipulate on the facts. So they're really fact specific. So know the test at least. Have a few of the cases kind of in the back of your mind, but you could really make a good argument when you get a fact scenario, you can make a creative argument either way. And the monetary, if any direct interest, obviously pecuniary or otherwise, is going to give rise to disqualification. This one's more clear-cut. If someone is directly benefiting, there'll be bias there. Some other examples of individual bias, meeting with one party where you, in the absence of the other, that's a big no-no. Having a friendship, obviously, or a vested interest in the case, related to someone who has a vested interest in a case, financial interest in the outcome, shares opinions before the evidence and the arguments are already even heard, persistently favors one party during the hearing process. This one's really, really tough because often during a hearing you have all sorts of little motions or little battles that come up and objections and it's really a test on an adjudicator to be fair. It's almost like a referee. Sometimes when you're watching some sporting event, you can kind of tell you get a couple bad calls, and then they give one to the other side just to kind of even it out. But do you ever do that?
Never.
Expressing a strong like or dislike for a party or witness, that's also very obvious. Has been in litigation against a party or witness. When you're dealing with decision makers who are often lawyers, there's a good chance they've had previous dealings or business relationships. It doesn't always mean, again, that there is bias, but from an arbitrator's perspective, the best thing is to do, if that is the case, is to put it out to the parties right away. To say, for the record, I used to be in practice with this firm, and sometimes an adjudicator, knowing what case you're going to hear, you know who the parties are, may even say to their manager, they won't even hear the case. Why even risk it? Why risk having to stop halfway through? There are certain parties, if they know professionally or know personally, they'll just get another arbitrator to sit on that case. Has a significant professional relationship with a party or a witness, and accept gifts or favors from a party or a witness.
I think maybe we should say something about, in the scenario you might have a situation where a party raises bias, and when you raise bias, the person against whom you're raising the bias decides on whether they're biased or not. So
Yeah.
it's a bit of an odd situation, and in your scenario they'll probably say, no, I'm not recusing myself because I don't believe that I am biased, and they move on with the hearing. And part of your job is going to identify, whether that was the appropriate decision from a procedural perspective and maybe also from a substantive perspective. But that could be a scenario that you see, or it could be just a bias type scenario of some sort of a relationship, smells of some sort of a relationship that just isn't right between a decision maker and someone involved in your scenario. So be aware of that.
So according to what we talked about yesterday, if there's a motion to
Yeah.
dismiss the bias,
Yeah.
we still have to wait.
Recuse. Yes?
There's a need to wait until the end of the process, and we can feel about this.
Right.
We feel about everything.
Right.
Because it might be more. So
Right.
this is one of those things.
This is the Lorenz and Air Canada that we talked about yesterday. Yeah, but you got to raise it.
Yeah, afterwards, but make the official appeal after the end of the process.
Yeah, that's a really good point, because if you don't raise it, then what could happen is that remember the discretionary reasons why they might not let you do a judicial review is waiver.
Right. You didn't raise
Oh,
it.
well, you didn't raise it. Must not have been that big a deal. You didn't raise it. You'd have to explain why you didn't raise it. Maybe you only discovered the relationship after the fact. Maybe.
So,
But if,
I'm asking
Right.
for the thing that in a regular court, you can't appeal a decision about bias.
but you have to raise it.
Yeah, but I can appeal it before the end of the
No,
process.
not necessarily. If the
you could.
You
No,
could.
You could. You could. You'd have a little hurdle because they might say
finish the case.
exactly what you said. Finish the case. It might not even be a big deal.
Right.
But say I have the door open to appeal proceedings
Yes.
for them, while in administrative, I don't. I have to wait until they.
No, you could. I mean, we talked about when it's really, when you're really not able to present a case. You may be able to appeal it prematurely, right? Because the case hasn't ended. But you want in your answer, you want to say there could be an apprehension of bias based on this relationship or this problem, and I would raise it so I could later make a claim to the reviewing court. That there was a procedural fairness issue.
Right. Or if the question was, give advice to a client, you'd say, well, our plan would be we'll raise it during the hearing. They might not do anything with it because they might say, oh, well, it's premature. It might, it's too early for that. But we'll raise it to protect our interests later. Or you'd argue you'd raise it because I think in one of those cases, the other side says, well, you're going to make us go through 4 days of expense or how many days of expense and the witnesses only to fight it out later. Like, you'd have to really balance how far along you were in the hearing and the costs and
I believe, not from the standpoint of view, but he said the three clear advantages of raising this matter. First is the people with integrity and ethical consideration from their own they refuse themselves. Second is what he said is absolutely right. You can blow it up right now. No, I brought this up. And I think third incidental advantage is that if at all a person has some at the back of mind, some biases, he'll be very cautious. He will not allow that bias to come forward because the thing that has already been pointed to. I think in such a setting, raising the issue by way of motion is an appropriate.
And it always has to be done delicately as well, because if you're practicing in an area, some of these areas are very small. You see the same decision makers in the same council all the time. You don't want to be throwing the bias card around, right? Because you're going to see them again, and they're going to remember.
Right, you're going to alienate the decision makers.
That should be in a very, very appropriate sugar-coated language.
Yeah.
Without offending them.
It's a good.
And this, and I don't know if I'm asking questions that are outside of the scope, but I'm asking them because it's really nice to be in the scope.
Yeah.
I know that in the regular judicial system, there is a presumption that the judge is a professional judge, so up to a certain level, if the article in some term or 30 years ago or something like that, it doesn't mean he's biased now.
Okay, you said the magic word, judges.
I know.
Very different from,
That's exactly the question. The question is, do we have in administrative law in Canada a similar presumption that says that there's some level of professional
Yeah.
decision-making that can
sure.
overcome these kind of day-to-day biases?
Well, it's a reasonable apprehension of bias. So it's an objective test of that reasonable person out there. So would a reasonable person think that I'm biased just because I see the same party for 100 times over the last 5 years? Is that it somehow affects my impartiality or neutrality?
I don't know. I've never heard it described as this presumption, but maybe I think it's there. But maybe it falls more in this within the test of, yeah, we went to law school together, but wow, that's hopefully you can overcome that level. Or sure, we even worked together, but again, in some places you're going to have worked with a lot of different people, right?
Yeah.
And it's safe if
Full
it's on
disclosure.
the line, you
Full
disclose
disclosure.
it and you see if the
Yeah.
parties, a lot of the times the parties, they don't care. So if you disclose it and you say, oh, I just want to put that out there, they're like, yeah, that's no
Full
problem.
disclosure, 17 years ago, I dated this party's third cousin twice removed. Does anyone have a problem with that? Does anyone object?
Yeah. In real life, most people, if they feel like, oh, this is not going to look good, the arbitrators themselves, they'll try to avoid it before they even get in there because they don't want to start, waste everybody's time and halfway through it gets raised. The trickier ones are when we have had cases where parties feel like the arbitrator's just really needling on them and not fair, and those ones get hard to prove because, as Deb said, you're raising it with, it's an odd situation, you're raising it with the person who you're saying is biased, and they're the one who has to then say, no, let me hear submissions. No, I think we can continue. It's a little bit odd, really, right? Okay, so then there's institutional bias. This is impartiality of a decision maker. So when you're looking at the individual, you're looking at their state of mind often, whereas independence of a tribunal is more about status. And there is a requirement for an institution to be impartial. Note, though, that a statute could require some amount of partiality. So sometimes it's like a built-in bias. Okay? So the tribunal must follow certain government policies. Sometimes the chair of the tribunal has to give annual reports to the minister. The tribunal gets its money from, or the agency, from government. And that budget has to be approved by the minister. Okay? So that's the kind of arm's length or relationship that we're looking at there.
So what is the case in this case with the advocate or decision maker is required to follow the government policy?
Yep.
Where you will put the case of bias or not?
They are
This is the general policy.
right. So these kinds of cases are a little more tricky because, just because you're created by statute and there's policies to follow, a lot of those policies may be just purely administrative, how the operations of hiring people and running the place kinds of things, very different from a ministry saying, you know what, when you get these kind of cases, we want you to decide like this. Okay, that's pretty obvious. If you have that kind of control from the government, pressure, that's obvious bias. Just because the government happens to be the one that approves a budget for your organization isn't necessarily meaning that there's not enough independence. The test you want to use for institutional, it's very, very similar. You can even use liberty as well, but also look at the Lippe case about institutional impartiality. So whether or not any particular judge harbored preconceived ideas or biases, if the system is structured in such a way as to create a reasonable apprehension of bias on the institutional level, then the requirement of impartiality is not met. It's the same kind of language here. You're just looking at the structure this time instead of the individual. Steps for analysis to determine whether institutional impartiality exists. Step 1, have regard for a number of factors including, but not limited to, the nature of the occupation of the parties who appear before this type of judge. Will there be a reasonable apprehension of bias in the mind of a fully informed person in a substantial number of cases? So it's just a slight little tweak, but it's still the reasonable apprehension of bias test. Step 2, if the answer above is yes, then consider what safeguards are in place to minimize the prejudicial effects, and are they sufficient to guarantee institutional impartiality under 11D of the Charter. Now, this particular case was looking more at the courts, and they used the Charter, but it still has an application to administrative institutions as well. So some examples, if you want to take all the cases, and some of the cases, even in individual bias, fall into multiple categories, but some of the types of institutional bias you'll see is a closeness between the agency or tribunal and the government, the issue of subdelegation, intra-agency consultation, and we're going to look at each of these in more detail, the need for consistent decisions and guidelines, and multiple and overlapping functions of counsel and the decision maker. So on the issue of closeness between an agency and tribunal, some of the questions you're going to ask yourself would be, how much power does a chair have over appointing panels? Okay. Meaning, does the chair of the tribunal, who's, think of them as the, the kind of the manager or the head of the tribunal, do they have some independence, or are they told, no, you're going to hire this person and this person? Is there someone pulling the strings of the chair behind the scenes? Are agency staff employed by the agency or by the government? How much does an agency have to follow government policy? Is the agency chair subject to a performance evaluation? And does the agency's government department decide its own budget? Okay? That's not a conclusive list, but those are the types of things. If you think that closeness is, or there's not enough, I guess, of arm's length distance between the government and an agency, there could be an issue of bias there. Yes?
Cases where the agencies sometimes is a subsidiary of the government, so that automatically.
It's always.
No, because they're always actually. So when we,
Yeah, it's always. It's
yeah,
almost
it's
always.
acceptable because it is always like the Human Rights Tribunal, all the labor tribunals, all the tribunals
all
we've
of
been
them.
talking about actually have a
Ministry.
like a home ministry that does just this: policy, funding. All the funding for these tribunals come from the government.
And for most of them, the hiring is not done by the tribunal itself. It's an order in council. It's the parliament appointing, the government appointing the member. But it's okay. People have been fighting over this for a long time, saying, where's the independence if you're appointing? So you're appointing somebody for 2 years, and then if you don't like the way they make decisions, you just don't reappoint them. So where's the true independence and impartiality? But that's the design that we have in this country. And remember that, administrative decision makers are not getting the exact protection that is expected from judges.
Yeah. And remember too that that first question in the checklist, is it a public body? All of these tribunals are public bodies, which mean they all have some connection to government. Now, they're created by statute. Right? They're created by statute, and they're serving the public. They have a very specific function. They were created for a very certain specific reason. So there is some independence from those ministries. That is a precondition. There has to be. They can't just be puppets for the government to say, yep, decide all licenses in this way. But their purpose, why they came up and they were created in the 60s, 70s, 80s, really were to add more efficiency to the government itself. Yeah.
Yes, it looks like what point number 2 is saying, that how much does an agency have to follow government policy? I thought they really implement government policy.
They really are. They are to do the work of the government, but to still be, when they're called agencies, they're not necessarily government employees necessarily, right? Or they're not within the ministries. Think of it as layers. You have the ministry staff, right? And then you have all the various agencies that report to the ministry, but the reporting isn't, it's more of a report back, or here's your budget, and obviously they want to know how you spend the money, because the money is coming from the government. But as long as they're not dictating how to decide, how those decisions should come out, that's a real key. Because if the government is basically dictating how to interpret, that's the job of the adjudicator. Right? That's where the independence has to come from.
Minister of Immigration, he appoints chairman and IRB officers or immigration officers, they overrule minister like Advocate Tribunal, IRB, Immigration Advocate Board. They overrule many decisions of the minister.
Yeah, they do. IRB is probably the last, has taken the worst hit for the being seen as being just mere government appointments. In the past, many years ago, some of the appointments for the tribunals were sheer just, you know, hey, I have a friend who needs a job here, let's appoint them to this board or that board. It is much more standardized today. These appointments that Deb has talked about, yes, they're still appointments, but it's regulated, it's very streamlined. There's a lot of oversight that goes into it, whereas literally in the past, you'd have people on the Immigration Refugee Board who had no experience in that board. So that goes against these tribunals needing to be people with specializations. Now, the people who are on, you know, immigration and human rights, they're usually lawyers who have practiced in that area. It's very difficult to get those kinds of jobs because they're looking for experts. Labor arbitrators, also known as, you know, they have real specialty or real expertise in their area.
I think the Baker case itself illustrates the administrators they have to follow in general government policy, no doubt about it, but even guidelines they have to follow. That's what exactly
The guidelines. Yeah.
they're not even following, they're just limited.
Well, there is always the policy and the guidelines, are they there as guidelines or are they to be followed? Again, it gets a fine line. And so those are the kinds of questions when you're looking at this. It's not an exact formula, but you're looking at how much independence do the decision makers and does the tribunal have from the government. Administrative decision-making bodies have been created in a way that leaves them connected to government. That's just by their very nature. Most of them have a link with the executive branch through a minister of cabinet, and generally under their enabling statutes, tribunals, or at least their chairs, are required to maintain some contact with the minister. So users of the tribunal might be concerned that the minister might use these opportunities to dictate, whether explicitly or implicitly, how particular files should be decided. You're always going to have people who have a conspiracy theory thinking, oh, you know what, these aren't neutral, but, you know, for the most part in real life, the minister themselves really don't get involved on the ground level. And the other area in institutional bias is subdelegation. So this sometimes creeps into some of the scenarios, and it's making sure that, because again, these tribunals are created by statute, right? All the powers that they have to be within the four corners of that statute. Okay? So if the decision makers are doing things that they don't have jurisdiction to make, that decision is going to be probably sent back or be considered to be unreasonable. So the person making the decision has to be authorized to do so. And the general principle is that the decision must be made by the person who is identified in the statute, unless delegation is permitted. And the statute will usually specify how many times can you delegate. So obviously, it's not usually ever the minister who's making these individual decisions. It's his or her delegates. And that's usually prescribed by statute, no problem. So sometimes it means the person personally, and other times the statute permits some delegation. So you have to really look into, is the person making the decision, have they been authorized to do so? You have to do a little statutory interpretation to answer that question. What are the practical realities, and what is the practical interpretation consistent with the language and the purpose of the statute? Okay. If you are a decision maker, can you delegate your duty to decide to someone else? Okay. So it's permitted when a statute says that a ministry may do something, it is specifically authorized, or is it implied? Otherwise, whether it's allowed depends on the nature of the power that's being delegated. So if you see a scenario that has improper delegation, the effect on the decision is that it's invalid. Sometimes you'll see this in the case of admin staff making decisions about process and procedure that really only the arbitrator is authorized to do. It might even be really simple little things. For example, someone would like to change the date of a pre-hearing or a hearing, or someone's looking for an adjournment. So you really need to look at the rules to see, can that be done administratively by a support person on the phone, or do you actually need that to go in front of an arbitrator for a decision? And the statute will tell you whether and what kinds of powers can be delegated. A procedure cannot be avoided by delegating it to someone else who is not subject to restraints. So the common law rule is if Parliament has delegated authority to you, you cannot further delegate your powers away. There's presumption of deliberate selection. The legislature chose the tribunal for a reason. Rule of law says that government can only infringe on your rights in accordance with the rule of law. Therefore, a secondary delegate has no legal basis for exercising their authority. This also might come into play in a scenario if you have a decision maker who gives the case away and makes it look like almost like an investigation, like, here, go and investigate this and make a decision. If they're investigating and making a recommendation, but you still have the delegated or the proper person making the decision, then that's fine. But if it looks like one of those rubber stamp kind of situations where, I'm supposed to decide, I'm going to give it to an investigator, and you know what, no matter what they say, I'm just going to follow it, that's probably an improper delegation. Right? You're giving over your decision-making power to someone that doesn't have the statutory power to do so. Practically speaking, though, this is a bit of a weak rule. It merely tells us to look at the enabling statute to determine whether the tribunal can further delegate its powers. Where a tribunal can show that they have come up with a better solution than what is provided by for statutes, courts may actually allow a new solution to stand despite the violation. Okay? This may be the case where, again, that admin or support staff, so maybe it doesn't make sense if the tribunal could show, you know what, the support staff can make a decision about changing a hearing date. That's totally fine. We don't need to send those decisions to a decision maker. Okay, you get a strong argument there that you're probably not breaching anyone's procedural fairness by doing that. I've included a few cases there under subdelegation. So the Jeffs case is Milk Board delegated a committee to investigate supply and report back. But instead, the committee went ahead and heard the actual appeal. There was no delegation of the power to hold a hearing. Even if there had been, the board did not receive summaries of evidence or submissions, but merely approved the determination of the subcommittee. The court suggested that a summary of evidence might not be sufficient if credibility is an issue. Some decisions actually have to be made by the minister personally. Not many, but you can see in the immigration context, deportation decision, very serious. The minister must consider both her own staff's submissions and those of the person concerned. An older case, House of Lords case, wow, that is old. An appeal by an owner of a condemned house to a local government board was delegated to an inspector to hold a public inquiry and report findings which were merely confirmed by the board. Okay, so that's the example of, you give it, I think you might see sometimes some of these in the examples. You give it off to an investigator, and they basically are making the decision for you. Okay, so watch for that. The Payne case, a former commissioner filed an affidavit suggesting Human Rights Commission considered extraneous factors when they dismissed a decision. The person to be examined was not a commissioner, but a staff member. 2 judges of the Court of Appeal permitted the examination of the registrar, whereas here there was evidence of impropriety beyond mere speculation. The dissent said that affidavit provided mere speculation. It's not necessary, this high threshold of reasonable, reliable evidence. I don't know if we need to go through all of the delegation cases. Well, actually, maybe a few of these, because these are some of the discipline cases. They fall into their own category. The first one there, Vine, labor legislation gave disciplinary power to the National Dock Labor Board, cannot delegate further to a subcommittee. Judicial nature of powers is a strong factor against delegation. It would not have been acceptable to delegate only the taking of the evidence and the reporting. Okay, so let's go to the third area of possible institutional bias, intra-agency consultation. Now this connects to the principle of she or he who hears must decide. The issue of consultation poses a big challenge to administrative tribunals because there's a bit of a balance. They want to, for their users, they want to have a consistent body of case law. They want their users to feel as though if I have this kind of case, I have a rough idea of how it's going to turn out. And that's just good customer service. You could say it's access to justice issues. So there's this need for consistent decisions, but you don't want to breach the principles of natural justice in that only the person who actually hears the case should be the one who's making the decision. So it's improper for anyone who missed part of the hearing to help you decide, and it's improper, probably obviously, for anyone associated with the tribunal to pressure the panel to decide in a certain way. There are some exceptions and limits. If a member of a panel cannot complete the hearing, let's say you do have a multi-person panel, if one person can't complete, it might be fine for the other two to continue. Parties might also agree that maybe a new member could take the transcript from the previous hearing and use those transcripts. And we have had that situation at FSCO where someone has become very ill or someone has retired and they're kind of halfway through a hearing. And so what do? You can't force the person to finish the hearing, so the next arbitrator, with the party's permission, took the transcript from the first hearing and then continued on. Not all parties would agree to that because there could be credibility issues, and you'd probably want the arbitrator making the decision to hear your witnesses live if there were those kinds of issues. But it's not, exceptions can be made. Should we take a quick break or maybe 10 more? We'll do this,
Just get to
this trilogy.
Just a few more things.
Few more? Okay, so the trilogy of cases on this she or he who hears must decide is Consolidated Bathurst, the Tremblay case, and the Ellis Don case. So 3 Supreme Court cases that actually looked at this whole idea of consultation. Okay? And they recognize when you're part of a large, busy tribunal, yes, consistency is important. Privative clause prevents the court maybe from dealing with inconsistencies. But at the same time, you want the adjudicators to also be able to consult with colleagues for the purpose of consistency, but not feel pressure to decide in a certain way. So the trilogy of cases said consultation is fine, but as long as these factors are there, it has to be initiated by the adjudicators themselves, so they have to voluntarily go to their colleagues for advice. It must be limited to questions of policy and law. So, for example, I can't say, you know what, this is what this witness said. I don't know. Do you think she's a liar?
No, but you can say, Liz, I'm dealing with defining the term disability. What do you think the legal definition of disability is?
You could even say, here's the evidence, that I received. Do you think it fits in that definition? But you're consulting. It's thank you very much for information, but it's not having Deb say, well, you know what, I heard that the chair really does not want these cases to be decided in this way. You better decide this way. The evidence cannot be reassessed, so the facts have to be taken as found, and if new issues and facts are introduced, then you have to go back to the parties and let them comment on it. So almost like the arbitrator would have to reopen the hearing. And sometimes this happens where, let's say, you finish the hearing, but then a really important case from Court of Appeal or Supreme Court of Canada occurs. It's right on point, but you didn't hear submissions from the parties during the hearing. you could say, parties, I have this case, I'd like to consider it, give me some submissions on it.
Because there may be generally two parties, one member and but this goes up and that party may not like this.
They may not like it, but if you as the adjudicator, if a Supreme Court case comes out and it's right on point, you'd be doing a disservice, I think, to the parties not to consider it, because it's
Fair hearing.
fair hearing, and if you're going to consider it, then you have to let them know you're considering something that they didn't have a chance to comment on.
So you got to give them the opportunity to tell you what they think this case is all about and how it applies to your case. Back to fairness, right? Just fairness.
And the main issue with these consultations is just no pressure. You can consult, but no pressure. The Consolidated Bathurst case was a board member could request a full board meeting when they were looking at changing policy. So some tribunals do have this where, a whole kind of almost like a group meeting happens to discuss different cases. They had to present draft reasons, okay? So not a final decision, but there was no compulsion. They didn't have to do it. There weren't minutes being taken at the meeting. It wasn't mandatory, and there wasn't a vote. The dissent said they did not believe that there was any real distinction between policy and fact. The court said full board meetings are practical means of calling upon the accumulated experience of board members when making an important policy decision, and obviate the possibilities of different panels inadvertently deciding the same issue in different ways. So there is positive that can come out of these discussions. The rules of natural justice should reconcile the characteristics and the exigencies of decision-making by specialized tribunals with the procedural rights of the parties. Because you really don't want, again, for access to justice, good customer service, you don't want the same issue to be decided all over the map by different arbitrators. People won't know what to expect when they come to your tribunal. In the Tremblay case, they had the Social Benefits Tribunal used what's called a consensus table. And in that case, the court actually found that system was flawed because there was this systematic pressure in the very way that it was conducted. It was more or less compulsory, so you don't have that voluntary nature. The president, not just the tribunal members, could initiate it. A vote was taken, minutes were kept, so it was very formal. Everyone had to put their position on record, and the president could resolve a disagreement even though they didn't hear the case. So that's the most extreme of the consultation cases. So in this case, they found that there was a reasonable apprehension of bias because of an expressed opinion from the outset, and I would say it's a good example of some systemic pressure. In the Ellis-Don case, a draft decision revealed a change in a factual finding. So there was an attempt to examine the panel members was dismissed. Deliberative secrecy is important to protect the value of the consultative process and independence. So without evidence that facts were discussed, you must presume that they were not. The dissent in that case said, well, the change, though, was enough. Just the fact that there was a change in the draft decision to the final decision seemed like there were some improper discussions, but that was the dissent. So again, so I would just look at those factors in terms of when you're, if you're faced with this kind of consultation, and go back to the must be voluntary, limited to questions of policy and law, no pressure, and evidence can't be reassessed unless you're going to give the party a heads up about that and let them make new submissions. General rule is that policy and adjudicative areas of a tribunal should operate separately. I think someone asked that question about how do you keep, the policy arm of some of the ministries separate. At an administrative tribunal hearing, agency counsel may have a number of roles. Oh, okay, sorry. Now we're moving into the role of agency counsel. So some tribunals, not many, but some have the luxury of having their own lawyers as well to assist at various stages of the procedure. And that lawyer may advise on procedure, may comment on the admissibility of documents, or on other policy considerations. So some of the concerns, if you have these decision makers and all of a sudden you have the tribunal lawyer involved as well, you want to flag situations where you have the really overzealous agency counsel who actually are trying to run the hearing instead of the tribunal members. Sometimes agencies will have counsel where the panel themselves might not be lawyers, because there's a lot of different tribunals, agencies in Ontario, a whole host of them, and they don't all have legal training. They have hopefully adjudicative training, but they're not all lawyers. So again, you just want to watch for any person, lawyer or not, who's trying to step in, run the hearing, because it's a delegation issue and it's a bit of a consultation issue as well. Agency counsel's role in the preparation of reasons as well. So sometimes you won't see the lawyer at the hearing, but you know they're there to support the decision makers when they're actually writing their decision. Right? At the Human Rights Tribunal, the counsel there reviewed every single decision of the adjudicator before it went out. Now, it was a fine line. We would review everything. If there was some glaring legal mistake, right, then it really was our role to say, you know what, my review of the case law says you got the law wrong here. Okay? So it's not to reassess the evidence, but it's to make sure that adjudicator has got the law right. In the end, it still has to be that if that adjudicator wants to get the decision out in the way they wrote it, that's their decision. But the counsel's role will be to say, you might want to look at the case law. Most adjudicators, they don't want to get it wrong. They don't want to be appealed or reconsidered. So obviously most are going to take the advice from counsel, but it can be a fine line. How much influence does counsel have? The difficulty if you're appearing before a tribunal like that, you're not going to know, as a participant or a party, you don't know how much influence the lawyer has versus the decision maker. You're not going to be part of that. So watch for cases in the scenarios. Watch for cases where lawyers have overlapping functions. Maybe they're doing investigations and the prosecutions. Counsel's advice to the agency is subject to solicitor-client privilege when it's given outside the hearing context. If advice is given during the course of a hearing, parties must be aware and have the opportunity to respond. Counsel must not appear to be in fact running the hearing. Decisions have to be made by the decision maker. Counsel can't be seen to be taking sides, and counsel cannot provide advice during deliberation phase, but they can assist in the preparation of reasons. Okay? So again, this is similar to almost a peer review. Sometimes adjudicators will peer review a decision before it goes out. It's just good practice. If you see a glaring mistake in the law, most decision makers, they want to know that. I've listed a couple of cases for you to look at in terms of lawyers who assist in drafting reasons when they've gone too far or not. There you have the Carr decision, the Creever, and the Bovbel. The font is so small I can't even read that. Okay, couple more slides here. Consistent decisions and guidelines. We've talked about this a little bit, but again, guidelines govern the internal operations of a tribunal, and attempts to apply the collective wisdom in interpreting a statute has to be balanced with the need for individuals who are in the hearing versus consistency. So I think we've covered, there is some overlap here with the consulting, but sometimes you'll have a clear actual guideline, a written guideline. So you'll want to know, is that something that is there for assistance to the decision maker, or are they bound to follow it? Okay? If they're bound to follow it, there could be some independence issues or some institutional bias issues, because a guideline that says if you get a case like X, you must say Y, that is infringing on a variety of areas, but mostly it's the person that hears who it's. You're treading in the job of the adjudicator. It's their job to interpret the law.
You're closing their mind, right?
Yeah. So there are limits on the use of these non-statutory instruments. So yeah, keep in mind they weren't part of the legislation. They're usually developed by the tribunal itself. A non-statutory instrument has no effect in the face of a contradictory statute or reg. A non-statutory instrument cannot preempt the exercise of a regulator's discretion. It cannot impose mandatory requirements enforceable by sanction. So de facto laws, but disguised in guidelines. Okay. Questions?
When we talk about guidelines, because there are many types of policy guidelines and policies, and one of the main one is regulations. I level things of that term, because but regulations are still not work of the legislator. So my question is,
They are, actually, and they are, yeah.
Regs are, they're just easier, they don't follow the same sort of first, second, third, but they're a subsidiary legislation. So there's when we looked yesterday, there's the Insurance Act, but then there are the Statutory Accident Benefit Schedule, which are regulation, which is law.
okay, so I was just going back
Right.
to what was said about the question if guidelines of policy are advisory or mandatory.
They can be both.
Upon the decision maker. When we're talking about these kinds of policies, we're not talking about regulations, because regulation
No.
can actually
We could.
bind these.
No, we could be talking. You could have a situation where the regulation refers to a guideline that's been developed by the tribunal.
But that's different. Okay, so
That's
you're,
different,
The
you're,
question is this: is it legitimate for the discretion to be limited by the regulation, and that would be valid? So the regulation says to the decision maker, if circumstances are X, you need to do Y, and that's regulation. So then it's not biased. It's okay.
that is fine.
Yeah, that's
That is fine. It might be phrased more like, in assessing expenses, you must consider A, B, C, and D.
You can only consider from A, B, C, D, E, and F. This is your criteria, decision maker. You're not going to consider whether this person has or doesn't have money. You're not even going to think about that. That's not going to form your determination of your decision. You're going to consider who won, who lost, who made this process longer, who made an offer to settle and didn't. You know, you're not going to think about other things. So yeah, so here it is, a regulation that is sort of, putting decision makers in a place where fencing them in, and that's okay. And a guideline, I think, is a lot more.
The purpose of a guideline generally is to actually
To help.
is help the decision maker, help the parties, help everybody. It's to give kind of a message. Here's a new piece of legislation, and the guideline is supposed to be the user-friendly way to say, here's
Here's
how
what we
we
meant.
like. Here's what we
Here's
meant.
what we meant.
Here's what we meant.
Here's
Yes.
what we meant in the enabling legislation.
Right.
Here's what we meant. Here's what we want you to do.
Yeah. Here's what we were hoping.
Here's where you would end up. Here's our objective. Here's the intent of the legislation.
Now,
Here's-
just to
right?
make it more complicated, as Deb said, there are some instances where a guideline it's called incorporated by reference. If a regulation or a statute refers to a guideline,
It's not binding.
it is, if it's incorporated by reference, it is binding. because it's just by reference, it's like it's brought in.
However, there's still that discretion to look at the facts of that. You always have to be open-minded, I think, and look at the facts of your particular case and how they fit into the guideline, right? So that discretion is there. You can decide that this particular case doesn't fit. You can decide that this particular case fits, but you still have to go through that exercise.
And from our experience, most adjudicators aren't so keen on guidelines. They're helpful, but they want to maintain that independence. So they don't like to have the feeling of they're bound by the guideline. I'll refer to it. It'll be one piece that I'll consider, but, government, do not tell me what to do because I have, you are fettering my discretion if I can't go outside the guideline. The guideline is usually just, I'm going to consider it, but I'm going to consider all these other things too. Okay. Just five more minutes and we'll take we're almost there.
3 slides.
Three more slides. Okay. So, multiple and overlapping functions. Now, actually, the Law Society scenario was a really good example of this, where if you found as though you had, your investigation department was also your decision-making department, that would be a problem. There would be some institutional bias there if the lines weren't drawn. You have overlapping functions could contribute to institutional bias, right? You can't have the people recommending, investigating, also the ones prosecuting and deciding. So there should be a clear separation. And then I've listed a couple cases there as well. That first one, the Quebec case, a lawyer could be involved in all stages, including the referral and prosecution and preparation of the reasons. The same director could both decide that a hearing was to be held and then hear the case. But remember, let's go back to that test again. Okay? So just because you have overlapping functions, you still want to look at the test where is there a reasonable apprehension of bias? And even if you answer yes, but did the tribunal have some safeguards in place? Because maybe there are reasons for these overlapping functions and the tribunal has created some structural ways to protect against it. Okay? So it's not an automatic, oh, look, overlapping functions, definite bias. You still have to look at the questions. In that second, the Sam Levy case, the superintendent of bankruptcy had statutory authority to both investigate and to adjudicate. But the safeguard was you delegate the adjudicative functions, so you don't do both in the same case. Just because you can, you don't do them simultaneously. And then the ISDIAC case, the minister makes decision to refer an extradition to a judge, also decides whether or not to hand the person over. This is okay in this case because they found that there was a buffer in the independent determination by the judge with some procedural fairness. So those 3 examples cases are good examples of where there's some institutional safeguard in place to buffer or protect against the bias. Oh, and there we are. Okay, so let's take a little break, 15 minutes or so, and then are we going to do?
We'll take up the fair wages, and then we'll finish off independence.
Yeah, perfect. Okay, so when we come back from break, we'll take up that fair wages scenario that you read over lunch.
You must be.
checklist, how would you start? So this is a good example where it says, prepare that memorandum. So following your consultation with the president of Magic Construction, the senior partner asked you to provide him with a memorandum on whether there is any basis for judicial review at this stage on the process. Okay? So from a practical perspective, really highlight what are you being asked to do before you dive in and think, okay, I'm going to just start doing a huge analysis. Really make sure by the end of it you're answering the question. In this case, is there a basis for judicial review at this stage of the process? It's a very specific question. How are you going to start off? If you've used kind of the checklist as a guideline, what are some of the questions that you're going to ask yourself? Barry, if you look at the very first page of the checklist, what's your first question here? I'm hoping that if you got two checklists, I hope they're the same checklist, because there's only one checklist. Yeah, that's where you start. Does admin law apply? Is this a public body? No. And it might be pretty obvious or simple, but so in this case, before you can determine whether there is a basis for judicial review, does admin law apply in this context? What do you think? Okay. Yes, and why? Right. Yeah, we have, they're acting under a statute, the Federal Public Works Act. Okay. So you want to kind of plant that seed. You might not need it to answer this question, but you see federal. You go, oh, okay. There might be some federal, we haven't got to that yet, but there may be some federal court procedures for judicial review, may be slightly different from provincial. So you just want to make note that we are dealing with the feds here. Okay, so what jumps out at you? If there is a basis for judicial review based on the checklist, where are you going to go next? I guess the other thing I'll say in when you're answering these, in this case they've said prepare a memorandum. They might have asked you to do a draft decision or write a legal opinion. Okay? You don't want to spend too much time making it look pretty, but at the same time they're saying prepare a memo. So I know that part of the course I think gives you a little bit of a
Exam
writing,
Tips.
right? So if they're asking for a memo, set it up like a memo, right? You have asked me to answer the question on whether there's a basis for judicial review, right? So write it like a memo.
They do that in is it the foundational? There is an exam writing course here, I know, that they do
I think
in
they
this
do
program.
a day or half a day, or maybe there's
Yeah.
some materials online.
I don't have a copy, but if you contact Megan
Yeah.
or Kate, you did it in foundation? Okay.
Okay.
So you need to contact Megan or Kate? Megan or Kate? They run this program, the NCA prep course?
I think they're just some basic kind of tips or materials on.
Issue, right? Issue identification, and, right? That IRAC, right.
Some tips on how to approach different types of questions, but more from a structural, like how to set them up, right? Not content-wise. So
Megan?
yeah, the
Megan
person
or
who-
Kate? The person who's in charge of the program, the prep course.
Yeah, Kate Wild.
Kate Wild?
Yes.
Kate. Yeah.
Yeah, the
Kate.
woman who was
Yeah.
here on the first day who said hi to everybody.
Yeah.
That's Kate.
Kate.
Okay, so what else jumps out at you, and how would you approach answering this question? So is there a basis for judicial review at this stage? Okay, so before you go yes or no, let's break it. How are you going to get to a yes or a no? Okay? And keeping in mind there's probably rarely ever a solid yes or no, but you want to work your way there to how do you get to that?
second point step two is there a right to appeal reconsideration review, etc.
Okay.
Until the stay like things are happening, and we need to go through.
Right? Yep, that's
The
a,
question is here, you don't have the details of the law. If the court no provision is clear, so we cannot say anything. We have to read.
no problem. But you can say anything, but you can say in your memo that it's not clear, it's not clear. However, judicial review is generally only available once someone has exhausted all internal levels of appeal, or if there's a statutory right of appeal, exhaust all appeal level first. It's not clear in this case, but if that has taken place, then that's how you would address it. Make a note that you do have to consider it.
And also, there should be some substantive decision for this to review. This is only investigation and reporting correction,
Right. That's
no substantive.
That's a very important point. Do you even have a decision here? Because remember, admin law applies to public bodies, great, but making decisions. Have you actually got a decision here? It's not exactly clear. You have a recommendation. There's been an investigation. Okay. So if you're going to stop at that stage, then you would, again, you'd want to say that there are, after exhausting internal rights of appeal, you might question whether, in fact, there is a decision here. Because if there is no decision, if it's purely just the results of an investigation, then at this point, yes, the court would likely say an application is premature. Okay.
Because in this case, it is very clearly written at this juncture. At this juncture.
Right. At this juncture.
Yeah.
Now,
The precedent of medical approaches like that.
Right.
So, it's obvious.
Now, yeah. Could you do a however in this case? Could you do a, on the face of it, if it's a mere recommendation, it would appear there's no avenue for judicial review. It's premature. However, you might want to, because remember, this is just a memo, okay? And again, take Deb's point about look at how many points this question is worth. If it's not worth very many, maybe they're not looking for very much. If it's worth a lot of points, they probably want you to dig a little further. However, if that recommendation is more or less always used by the minister and rubber stamped as a decision, then that may change the context here a little bit. Okay? So you'd have to do a little bit of speculation. You might have to do in this case, if it's not a mere recommendation, if it will be binding on the minister because the minister always follows the recommendations, then we may be able to pursue, go further. Okay? Let's assume we go that route, just for fun, because otherwise there's not really anything to talk about for this question. But especially if it's worth a good chunk of questions, because you might want to. Now that doesn't mean don't dump everything in the kitchen sink, just dump it all and hope you're going to get some points. Try to make it sound, yeah.
As you said, the minister will never
Yeah. Yeah. Because if this really was kind of a briefing or a memo, usually there's lots more questions to ask. So you'd say, we'd want to look further into the, the relationship between the minister, is it the minister? Yeah, we'd want to look further into what does the Minister of Public Works do with these recommendations. Right? So let's assume that in this case, in this world, recommendation is actually always followed. Okay? So now we could more or less have a decision. Let's start through the steps of procedural fairness. Okay? What's our step one question going to be? Because the question is, do you have an avenue here? Is there any basis for judicial review? Okay. Well, we know that the basis of judicial review can be one one or two of the following. You can challenge a decision based on procedural fairness, and or you can challenge the decision based on the substance of the decision itself. So you might want to have one of those intro lines, right? The reason for going to judicial review is you're wanting the court to review the decision for some defect. In this case, you might say, in this case, there are several potential procedural defects. But the first question we have to ask ourselves before you can go down that road is what? What's the first, in the checklist for procedural fairness, what's the first question you have to ask? Or the first hurdle? Yes? Right. Yeah. Yeah. Is a duty of fairness owed? And then again, we don't, they haven't given you the whole statute, so you'd say, in order to answer that question, we'd look at the enabling statute and possibly the common law. Right? And within the common law, you could also say here, because this is a public body making a decision about someone's rights, privileges, or interests, remember the threshold for his fairness owed is not very high.
Not very high in the sense that also bodies that are relatively removed from the government will have relatively weekly listed all the year.
Yeah, if you have a public body that's making decisions about rights, interests, or privileges, some level of fairness will be owed, some level. Right? This isn't a private company making decisions for private actors. So, some level. We don't know how much, but it opens the door saying, yeah, okay, it doesn't have to be the most formal quasi-judicial. We don't worry about that anymore, but since Nicholson says administrative decision makers and decisions are owed some fairness. Okay. So that gets us over that. And you would then look at, assuming that you don't have a clear statute, let's deal with the common law here, because again, the NCA wants something for points on the exam. If the statute's really clear, they don't want someone just regurgitating the statute. So they haven't given it to you in this case. So in that case, you can talk about the Knight case, right? That's the test. The three-pronged test in Knight tells you, look at the nature of the decision. Is it preliminary versus final? Look at the consequences to the person. So you go through the checklist and you'd say, okay, you know what? Looking at the consequences and the type of decision here, some procedural fairness has been triggered. Some procedural fairness is owed. Okay? Now, again, because it's maybe a preliminary decision, you could point that out. Might not be a final decision here. So if some procedural fairness is owed, it's probably a little bit less than a more formal final decision. That was that step one, is fairness owed. Okay? You talk about Nicholson, you talk about Knight.
In step one itself, I'm seeing the point here, the duty doesn't apply to investigations or the person, it applies to decisions.
Right. So you'll have to argue both. You'll have to say, if this is deemed just as an investigation, this recommendation, it may be premature, like you said before. But let's assume that the recommendation is always followed by the minister, that we can then treat it as a decision and get over that hurdle and get to judicial review. Right? Address those discretionary grounds of prematurity and assume that you can move on so you can get more points and actually going through the analysis of, whether the duty is owed and the content of that duty. And also keep in mind that this is a federal decision. So there may be federal rules, and you may be able to engage the Bill of Rights. If you need more sort of ammunition to trigger the procedural fairness aspect.
Okay, so if you decide you're going to keep going, that this isn't preliminary, or you want to give some alternatives in your answer, step 2 on the checklist says, okay, fairness is owed now. What does fairness look like? That's your opportunity, the 5 Baker factors. And then you'd look at those 5 Baker factors and you'd apply them to the facts of this case. Right? And remember, not all of them may apply. Once you've done that, then you want to get into the actual, well, what procedures jump out at you that may or may not be adequate in this particular case? Is there any procedures that you see here at all, based on the ones we talked about today? Okay, what procedures? What's one of them?
There's 3 points on notice,
Okay, notice.
right to be heard,
Right to be heard.
and bias.
Yeah. So in terms of notice, so you look at each of those. Let's say you look at notice. Okay? And using the 5 Baker factors, you decide, was notice adequate? Given all these factors in this particular scenario, do you think notice was adequate? And you'd go through each of the procedures to argue, maybe in this case, there was no notice. Yeah, in this case, it doesn't appear that any formal notice was given at all. So what they got was a summary report. Now, when we go back to that slide about notice, remember what the purpose of notice is. It has to have at least enough information on there. It has to have the who, what, where, why, and when of the hearing, and it has to have enough information for the person to be able to respond. Right? Now, this might be really stretching it in this case because we're not even really talking about notice, we're talking about a summary report. So again, we've tried to give as full of an answer as we can. It'll only make sense to you if you see how many points the question is worth. Maybe they wanted you to stop at the, this is preliminary, and so judicial review is premature. Period. Done. Anyway.
No, it's okay, because the problem is there.
Right.
It should carry at least 50.
Oh, there you go. So in this case, it really appears as though if no notice was given, you could probably make a good argument to say, well, procedural fairness is owed some minimal information. If you're going to take some benefit or right away from me, you have to give me notice. So that could be a clear breach right there. Right? You don't have to have 10 procedural defects. One could send it back. Disclosure was also seemed to be somewhat inadequate here. Okay? So you could argue that, okay, this wasn't really that, it's still merely an investigation, so maybe there wasn't this obligation to disclose, but if it was a recommendation or it was a decision, it doesn't look like there's any disclosure there at all. So that didn't meet the test either. There was no hearing, so you can't really talk about oral hearing or not because it wasn't even at the hearing stage yet. What about the bias issues? What jumps out at the bias? Okay, so if you're going to raise bias, then you start off with saying the test for bias is reasonable apprehension of bias, the Liberty case, and that's the standard you would use. So you'd include that in your memo. Okay. So the spouse complaining of the employee works for the decision maker in a really small office. Yeah, there could be something there, some personal bias there. There might even be an issue if you do have this rubber stamping of investigators always, the minister always approves the report. You might have a case here of delegation, that subdelegation that we talked about a few minutes ago. where the person who seems to be making the decision really doesn't have the authority to make the decision. But again, I'm kind of reaching a little bit, I'm stretching, don't have a lot of facts there, but if that's the case, there could be some institutional bias if the investigators, in fact, are really final decision makers, right? So then there's been some delegation there that's not permitted.
You would find that this, what you mentioned before in the trend, that someone tried to put the trend of decisions by statistical review, or this is something else? But you mentioned before about immigration.
No, something else where the cases where you have an investigator or an auditor or somebody, like a committee who's supposed to just make a recommendation, but really what they're doing, if that recommendation is followed 100% of the time, they're not really investigating because the person who's making the decision basically says, okay, thanks for the report, yeah, and isn't turning their mind freshly to that. So it's a little bit different than that. It's a delegation issue because, in a way, me, the decision maker, I've given away my authority to someone else who's not authorized. Yeah.
And we also argue the removals, no element of bias, can we also argue?
You could.
Because-
You could definitely argue both ways.
Because the ministers are weak. Somebody is working for the president.
But if you're going to argue that or put that position, you still need to put the test. The test is this, and here are some cases that are similar to this scenario. Here are some cases that are opposed to this scenario. And, in most cases, you could probably be creative to argue either way, depending on who you're, Exactly. And the question might also say, give us your best argument for, what's our best chance at initiating a judicial review in this case, right? Again, really think about what they're asking for. Okay, so the best chance is to argue in this way, and here are some cases that support that. You can always argue either way. Well, in most cases. Okay, so we will provide, probably maybe Friday or soon after, we'll provide some of those steps. What we've done in our sample answer is just really, we've taken the checklist and taken some of the facts of the scenario and thrown them into the checklist. Your sample answer should be written as a memo if they ask for a memo, as a decision if they ask for a decision. So, but we're just trying to give you a little bit of a roadmap to help, when you're given these fact scenarios, sometimes it's a lot of stuff coming at you, just to help you weed through it. That, not today, no. Probably by Friday, or let me just say soon after. I don't want to give you a legitimate expectation that you will get it soon after. I think that's being procedurally fair. Okay, so let's finish up our last few slides for the day. And if you want to read ahead, we will get to eventually, by Friday, all of the scenarios. If not by Friday, we'll do the scenarios, and then we have that extra day, July 23rd.
I think on Friday we'll probably try and get 2 more in. And by Friday, you're going to have to tackle the procedural and the substantive together from one scenario. And after I'm done with you on Thursday, you will be able to do that. So I think I guess it's not so bad to have the break tomorrow, because it really allows you to catch up and to start preparing for the substantive part. The substantive part is pretty heavy too, right? I mean, there's a lot of information that we feed you over a very short period of time, right? It's a very short prep course. But we should do the 2 scenarios on Friday, and then when we meet again for that it's an evening, right? For that 3 hours, we'll finish off the scenarios, and hopefully you'll be feeling quite confident by then.
Okay.
So,
On the stretch?
yes.
Okay. So, lack of independence, this is, to be honest, this was a struggle for us over the years of where to kind of put this piece into the grand scheme. And maybe you've read the textbooks, maybe you haven't. If you haven't, kind of don't blame you. They're not, it's not easy reading. but you'll see if you look at a variety of textbooks, the way that lack of independence, institutional bias, where it fits in is kind of different in each book. But the concept itself is not a difficult concept, but it is related more to institutional bias. So institutional independence is related to the concept of bias, but it's more about that systemic structure again of the tribunal. It's not about the individual decision making. And what the case law has looked at is really three specific areas, because they've taken as a starting point the judicial independence, which is the extreme of independence, right? Judges who have tenure, security of tenure, they're appointed for life, they're not going to lose their jobs. They have financial security, they're well paid, and they have a lot of administrative control, okay, over the work they do and their job function. Okay? So if you have someone, a decision maker, who has all three of those in a strong way, the idea is you can feel pretty confident you're going to get a decision that is made independently, free of pressure, free of bias. It's a reassurance to the public that the possibility of interference in judicial decision-making by the executive or the legislative branch of government has been reduced, if not eliminated. Judges also have adjudicative independence, the ability of a decision maker to decide free of inappropriate interference by other decision makers. Such inappropriate interference may include, for example, the pressure to decide in a certain way or to substitute one's decision for their own. So you see the overlap there with the previous section about delegation and guidelines and consultation. So we want independence because this is going to boost public confidence. The main test in this area for tribunal independence is the Valenti case. It was the first Supreme Court case in Canada to suggest the idea that the guarantee for judicial independence could also be applied to tribunals. The test for adequate tribunal independence is whether a reasonable, well-informed person, having thought the matter through, could conclude that an administrative decision maker is sufficiently free of factors that could interfere with his or her ability to make impartial judgments. So that reasonable person again. The standard for tribunal independence is not as strict as it is for judicial independence. Administrative tribunals do not have to meet the same degree of independence as the courts do. The methodological approach taken by the courts when the independence of an administrative tribunal is challenged consists of applying the guarantees of tribunal independence, but in a flexible way to account for the functions performed by the tribunal under scrutiny. And the court basically set out three criteria, so three areas that they look at to determine if there is enough independence. Security of tenure, financial security, and administrative control. If these are there, then there's a good argument to say that you can guarantee the independence, but note that the court also said this is also not an exhaustive list. It could evolve over time. This method was also stated concisely in the Matsqui Indian Band case, another Supreme Court case. While administrative tribunals are subject to the Valenti principles, the test for institutional independence must be applied in light of the functions being performed by the particular tribunal. So some flexibility. The requisite level of institutional independence will depend on the nature of the tribunal, the interests at stake, and other indices of independence such as oath of office. So another key case that falls within this lack of independence, specifically under the security of tenure factor, is the Oceanport decision. This case was the BC Liquor Appeal Board, was a liquor licensing body that could impose sanctions and remove licensing upon finding that a licensee had contravened the province's Liquor Control and Licensing Act. The Royal Canadian Mounted, the RCMP, had reported that Oceanport Hotel was responsible for 5 incidents that violated the Act, the regulations enacted under the statute, and the terms of its liquor license. So, cut and paste there. The Liquor Control and Licensing Branch, or regulatory branch established under the Act, consequently imposed a 2-day suspension on Oceanport's liquor license. The Liquor Appeal Board held a hearing de novo, so brand new evidence again, and confirmed the suspension, finding that the evidence supported 4 of the 5 infractions. On appeal to the BC Court of Appeal, Oceanport argued that the Liquor Appeal Board lacked sufficient independence to render a fair hearing. It submitted that the board's decision was therefore invalid. The hotel took issue with the terms of the appointment of the members of the Liquor Appeal Board. The act indicated that the chair and the members of the board were to serve at pleasure of the lieutenant governor and council. So in essence, the argument there was you can't get a fair decision from the appeal board, Liquor Appeal Board, because of how it's set up. Okay? The board members or the tribunal members are at pleasure, which means those appointments, right? Appointments right by the minister themselves. The case attempted to lay to rest the controversial issue of whether an at-pleasure appointment provides a satisfactory degree of independence for decision makers, especially those that are going to be imposing penalties. This was the Supreme Court's first opportunity to address the crucial issue of at-pleasure appointments, which were clearly not as secure as a fixed-term appointment. It provides reasons why administrative tribunals should not need the same degree of independence as courts, and clearly indicated that there is no freestanding constitutional guarantee of independence for administrative tribunals. This is because administrative tribunals form part of the executive branch of government. The court held that because constitutional guarantees of independence primarily protect the judiciary from interference by the executive, they cannot work to protect tribunals from the branch of government which they are a part of. At the same time, Supreme Court and other Canadian jurisprudence has shown a willingness to expand the notion of the court, the definition of court, to allow litigants before some lesser judicial entities still the benefits of constitutional guarantees of independence. So what you see here is the court is not going to say that tribunals and the courts and the judiciary, they're not on the same level. They don't require the same level of arm's length independence, but you can still, they should have some independence, but we're going to be flexible about how we determine that. So the Oceanport case did look at those appointments and said, let's not call into question the entire system only because of how these members are appointed. Okay? It's a factor, but it's not going to mean the entire system is not independent. The security of tenure came up again in the Keene case. Canada's Nuclear Safety Commission President Linda Keene was removed from her job over a decision to keep a nuclear power plant closed for its failure to meet safety standards. Ms. Keene applied to the federal court for judicial review. So this is more she's being dismissed and she's asking for a review of the dismissal. At issue was whether she received adequate procedural fairness in the manner of her dismissal. The court held that the circumstances of her termination were sufficient to satisfy the requirements of fairness for an at-pleasure appointment, which is how her appointment as president was characterized. The governor and council's dismissal was therefore upheld. So one question that might be raised then is how do you resolve these two cases? You have Oceanport saying that just because someone is an at-pleasure appointment, it doesn't mean that there's no procedural fairness owed to them, whereas Keene wasn't given very much. So it could be just an element of degree there. Oceanport affirmed that a variety of tribunal appointments could satisfy the requirement of security of tenure, so long as there are no constitutional standards at play and the terms of the appointment derive from constitutionally valid legislation. Keene shows that as a practical reality, governments still can and do interfere with administrative decision-making because of improper understanding about tribunal accountability. The federal court was faithful to the Supreme Court's guidance in Dunsmuir, which you're going to hear about on Thursday, which provided that a lower level of procedural fairness is required on termination of an at-pleasure appointee. The court in Dunsmuir stated, with respect to at-pleasure appointments, procedural fairness is needed to ensure that public power is not exercised capriciously. So it's still there. It's not that they're not owed any kind of fairness, but a lower level. The Bell Telephone case, still within the category of security of tenure, there was a challenge to a chair's power to extend appointments expiring during the course of a hearing. The case found that it did not offend the independence issue because the decision was made by the chair, not by the minister. It did not offend impartiality because there's no reason to believe that members would feel pressure to adopt the view of the chair. In the Sethi case, pending legislation would require all Immigration Board members to be reappointed. The reasonable person would not think that government would be pleased by a decision not in accordance with its merits. Do not want to create a chilling effect to the government's reappointment or the ability to change its institutional arrangement. Again, what you want to bring into each of these, it's still that reasonable apprehension test, right? The reasonable person test. Would it seem as though if someone's reappointment was happening in the middle of a particular decision, is there reason to think that that in itself would cause enough of a lack of independence while they're making their decision? The Lippe case we talked about a little bit. Part-time, but it also stands for part-time members of a municipal board were allowed to practice law at the same time. The court found that the likelihood of conflict was too remote to raise a concern for bias on an institutional level. The Alex Couture case, part-time appointment would be problematic if other activities of the member could put them into conflict. In this case, they found that that conflict was, though, very unlikely. So again, you see the cases are very context specific. So try to gather the general principles, right? The important factors to look at in terms of bias and lack of independence. In the Alex Couture case, again, the court looked at, well, these part-time appointments might put independence at issue, right? Because you might have people doing different things and they don't have a lot of job security in terms of security of tenure, but they also looked at, were there safeguards in place within the tribunal structure? So members were required to take an oath of office, very formal. There was a limit on the number of reappointments. There was a specific prohibition on financial interests, so meaning you can't sit on a case if you have a financial interest, if you're doing some other work that might connect you to that. Second category in those three factors, financial security. Idea is to ensure that compensation decisions are not arbitrary or otherwise susceptible to influence decision making, and that there is no need to supplement income. So in an ideal world, your decision makers have enough financial security that they're not going to be at risk at either having to do a bunch of other part-time work or maybe be susceptible to having an interest in the case itself. Judges have a fixed salary, and the decision is made by a remuneration commission. So there's a whole legal process in place for deciding judges' salary. There's no room for an arbitrary, okay, you get this much, you get that much. When you have a system with fixed salaries, it lends itself to a greater assurance to the public you're going to have that financial security and more public confidence. Right? If you have a system where the chair can say, let's see, I like you, so you get this amount, but you can have a little more, you're going to have a system where people might feel, if I do what the chair wants, if I do what the government wants, I'm going to get paid more. Right? I'll be in this other category. Whereas if it's very structured, there's no room for that kind of influence. At the Bell Telephone employee case, Human Rights Tribunal remuneration was set by the Human Rights Commission. a party that appeared before it, and they found that that was actually not acceptable, and that was ultimately changed. Okay? So at one point in Ontario, you had a Human Rights Commission and tribunal as separate bodies, so that the commission was actually a party appearing before the tribunal decision makers. There wasn't enough arm's length there. The Matski Indian Band, no guarantee of any salary at all, so theoretically could decide not to pay them if they didn't like a decision. I mean, highly unlikely, but it just creates that another level of instability. Lack of independence, those three factors, again, going back to the Valente, so the Valente is still the case that brought out these three principles to look at. Administrative control, and that concerns the manner in which the affairs of the court are administered. Avoid government control in, for example, the allocation of resources or the assignment of cases. You don't want to have be people handpicking what kinds of cases to get. Judges have a third party that negotiates the allocation of funds from the government, and cases are assigned by the Chief Justice. Tribunals generally have control over their cases, but the resource issues might be a little different than the courts. So there may be times you'd want to look a little bit deeper into what is the funding principle between the ministry and the tribunal. How close is it, and how closely is it monitored? Because if keeping the ministry happy means, you keep getting your funds, there's a problem there. Now again, raising those kinds of concerns, those are really big cases. The average person with their individual case is going to have a really hard time raising these independence types of issues. The Quebec Inc. in Quebec case, in Régie, it was held that the directors of Quebec's liquor licensing board possessed sufficient security of tenure, despite the fact that their time in office was limited, which is typical for most adjudicators. The Supreme Court of Canada held that the requirements of tribunal independence do not necessitate that administrative actors are like judges. The tribunal members or the adjudicators are not required to hold office for life. But you might get a scenario where an appointment every year, you can see how that's less security than someone who has a 5-year appointment or a 10-year appointment. If you've been appointed to a tribunal for 10 years, you have a little bit of, you can make some decisions that might be a little outside the scope of acceptable because you're guaranteed 10 years. If you only have 1 year, you don't want to screw up in that 1 year. You want to that's the reality. You want to be reappointed. It's your livelihood.
Can you raise this claim about someone at the end of this 10-year tenure? I mean,
Well,
for 9 years they're pretty independent, but now that they're coming to renewal,
Yeah.
it might be.
You could, yeah, because let's say that it's renewal time and you're appearing before them during the time and they're about to issue a decision, and the make or break, yeah, you could. Now again, how you as an individual would ever make that case really difficult, right? How would you even have that information? Maybe after
Well, it's all public, actually.
it is, but
Well,
how would you?
it's actually easier than that, because most members in Ontario, for example, who make decisions of all these boards and all these tribunals, they're part-time members, most of them. And you can go to a website and you see everybody's names, and you can see the year that they started and the year that their appointment expires. And there's also a limit on renewal. You can only be renewed, for example, if you want to be an immigration and refugee adjudicator, you can be renewed up to 10 years. You can't do more than 10 years. That's it. That's your max. You're not going to get more there. So, you can make an argument that a part-time adjudicator who's getting, 4 cases a month or 3 cases a month and getting paid by the day, per diem, per day, maybe is more likely to have less independence because they want to get more cases assigned to them, right? But the Supreme Court seems to very clearly say over and over again, sorry adjudicators, you don't need the same level of independence that we judges need. You are there the attitude is that you are there to apply the policy of the moment. Parliament's policy of the moment. So do it. And when the government changes and when the policy changes and you're not applying it, you're out. Practically.
And you have to go with the time frame. 10 years, like that was the
10 years max, but you don't always get the 10 years. Maybe your renewal's every 2 or 3. And then you get cut out after 1 or 2, right?
Yeah, it's very typical. Your first year you might get a year, then 3, then 5, then maybe 10, right? So, the respondent in that case also challenged the board's administrative control. It argued that there were so many points of contact between the liquor board and the minister responsible for the board's enabling legislation that the board's institutional independence was threatened. The court held that administrative control was also sufficient. It was not unusual for a minister to have many points of contact with the tribunal under its responsibility. The court noted no evidence had been provided to show that the minister could affect the decision-making process. So again, just because you have all these, maybe there's reporting about budgets and reporting about policies, it's not so unusual, and it doesn't necessarily mean the minister is telling adjudicators how to decide cases. And the Alex Couture case, again, a competition tribunal. There were limited term appointment was satisfactory where you can be removed only for cause. There was no specific statutory procedural protection for dismissal, but they would be required by common law and by application of the Judges Act, which happened to apply to federal appointees. The lower court was concerned because governor in council set the rate and the Privy Council received performance appraisal. But the appeal court was satisfied that the policy created enough distance, so they had an advisory group for salary, created enough distance the Privy Council received for human resources purposes only. So I think the case law is saying that, there is a lot of leeway and flexibility given in terms of security of tenure, financial security, and administrative control. They're not going to throw out a case too quickly and say, no, that case is not valid because of this lack of independence. It's not an easy argument to make. In the Katz case, lawyers appointed to Stock Exchange Disciplinary Committee. They had no terms and no guarantee of pay. The Supreme Court distinguished self-regulatory function from the adjudicative function in Matt's Key and focused on how the tribunal actually functioned in practice. There was no evidence of arbitrary removal. Basically, people were sitting on the tribunal until they resigned, and there was no evidence of payment issues. There was no evidence of interference by the executive. The chairs were selected by a manager on rotation. So an informed person would not be concerned about independence. Again, very case specific. Make sure you know what at least the test is, and then you could probably argue, either way for most of the fact scenarios that you were presented, but you need to know at least what the test is for bias and independence, and some of the factors that should be looked at. Right? You can always make the argument. You could say, in making the argument, these are the factors to be considered. Okay, so some other issues. Discretion. Issues related to the exercise of discretion has both a procedural and a substantive element to it. Discretion is the power to choose a course of action from options available. Okay? So we're talking about discretion of the adjudicator. Discretion must be exercised within the four corners of the statute. Right? So I described that all the powers of the tribunal come from statute. Officials must consider only the relevant factors. Similar cases should be treated in a similar way, and discretion must be exercised in good faith. Fettering discretion is when you refuse to consider an option available under the law or to consider any relevant factor when making a decision. It can also be when you rule out options, when a decision maker is ruling out options that they are actually required to consider. I think that goes back to that earlier question. Sometimes the regulation of the statute will tell you, right, what are the relevant factors or what are the factors. So the decision maker's decision should show that they've turned their mind to those factors. And then I think these last few slides we've actually addressed earlier, but that is the how do you raise an allegation of bias? Okay? Any of the above that we've just talked about. So as early as possible. It'll depend on, like the when might depend on the circumstances of the case, but it should be as soon as you become aware of it. The court will consider a party to have waived the right to argue the allegation if they don't raise it during the hearing, and the right is not waived if the party raises it, but the member continues to hear the case. So you want to get it on the record. If an adjudicator is concerned that there may be bias, they may ask the tribunal chair to just assign a different adjudicator if the hearing hasn't started. They may informally disclose the facts to the parties, which is always a good idea, and decide that it's in the public's interest to continue to hear the case if he or she believes that there is no actual bias or reasonable apprehension of bias. So they're going to think about a whole host of factors. Yes, the apprehension of bias, but if you're discovering this on day 4 of a 5-day hearing, there may be a stronger argument, to continue. For the cost, again, it's going to depend on the circumstances, but to the cost to all the parties having to restart a brand new hearing. The interesting dilemma we've talked about is if the adjudicator is giving reasons about why he or she feels there is no bias, in a sense, that adjudicator is giving evidence. Right? And usually an adjudicator isn't permitted to be a witness in the matter for which they preside. So could the parties, if the adjudicator gives their reason, could the parties actually cross-examine the adjudicator on that evidence? Just an interesting dilemma, not something that happens. I would say it's perhaps challenged in a submission, but cross-examination probably not.
Maybe this question is not arise as long as until the decision is taken. In this decision itself, you will write down this point for resistance, but before it like this.
Right. But in a sense, if the adjudicator is giving reasons, in a sense they're giving evidence. Okay, we made it through procedural fairness. You survived. Well, yeah, so I think we're going to stop there for today. And on Thursday, bright and early, 9 o'clock, we'll start into the next step, the standard of review. Oh, sorry, wait. Whoa. Sorry, I've missed 3 slides. Take it back. Although I'm going to gloss over it. Maybe it's a good point to start back on Thursday, because it's a little bit confusing. We haven't talked about what is this standard of review.
We'll do that Thursday.
Yeah. We'll do it Thursday?
Yeah.
Okay.
We'll do it Thursday.
Rewind. We are done for today. It will make more sense on Thursday than it would right now. It'll add confusion, and let's end on a high note. Okay, so if you have the time and interest, look over any of the sample scenarios. If you want to be a keener, try to answer them, yourself ahead of time. We will give you time over the next few days in class to work together, and we'll take them up, and then again on Friday. But if you want to work ahead, do so. All right, thanks everyone.
Thank you, Liz.